It is what? What is, when I deal with Section 45, what am I dealing with? My question is, if I'm dealing with Section 45 of the DRA, what am I dealing with? Amendments, says Alan. Not really amendments, but tell me, what are we dealing with in general?
We are dealing with a joint estate.
It's a joint estate. I don't know who said that, but it's a joint estate. It's an asset in a joint estate. That's it. It's an application, yes. It's an application, but we are dealing specifically with an asset in the joint estate. So can we all understand that Section 45 can never be applied when we are dealing with parties that are married out of community of property, where the asset is not part of the joint estate. So the first thing there is Section 45 only deals with the joint estate, the assets in the joint estate. Okay, right. So important, yes, to remember is that because of this, we have the possibility of not using, well, not even the possibility, it is there as an option always. I have a choice whether I want to do a Section 45(1) or whether I'm doing a formal transfer. Now, the thing with the Section 45 is the fee are less. The fee is less than a full transfer fee. It's a reduced fee. It's a percentage of your full formal registration fee. The thing with this is even though we have a choice, as I said to you before, the registrar is indeed a taxing master or a tax master, and therefore, if a transferee complains that you've charged him too much when there was a lesser option, it is possible for the registrar to tax you down and to reduce your fees to a Section 45 percentage of the application. So important there is you have a choice, but it's such an easy manner to do or to deal with the Section 45 that it's basically easier to do a Section 45 than it is to do a Form E. While you still have to have a transfer duty receipt lodged or exemption for that matter, because Section 45 is one of your exemptions, or in terms of Section 9 of the Transfer Duty Act, you still have to have that exemption, transfer duty exemption receipt basically lodged. You also have to have in certain situations, you have to have your rates clearance certificate, but you don't have to prepare a power of attorney. You just bring your application as such. It's a plain and simple application, and it has no form. You just lodge the application with the deed, and then the application, if it's in order, will be its effect will be endorsed against the title deed. Okay. So the thing with this is that if it's a 45(1), again, I reiterate, it's only our assets in the joint estates. It's not the out of community of property. And you always have to put this at the back of your mind. And Alan referenced this in the last lecture, and I didn't really want to go into that. But when we deal with bonds and we have Section 45 BIS applications and even Section 45(1), then we have specified forms that in terms of which we substitute the debtor. Okay, so if we are dealing with the joint estate and its assets, then when we deal with a bond as well, so for instance, Joe Soap is now dead, and his wife Jane Soap basically inherits the entire estate. And let's say they have a primary residence, and that primary residence has a mortgage bond over it in favor of ABSA, for instance. Then you have to either release Jane from the working of the bond, cancel the bond if there's sufficient money to cancel the bond, and if that is what is elected, And then the alternative is to basically substitute Jane Soap and have her assume the responsibility of the full bond in Solidium. So basically, she will become the only person that is liable in respect of the bond and its repayments. Right, so if we consider that, then we have to understand that I'm going to use either form T, form W, or form BBB. You can write that down at this point already, but just remember that when it comes to section 45s, there's three different forms, and it's form Benny, Benny, or Bravo, 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 BBB, T for Thompson, or W for William. Okay. So those are, when we deal with these the estates, we will look at exactly, with the bonds, we will look at exactly what each one of those forms looks like. So we're not going to go into that yet, okay? And remember, this is purely because of, somebody can just mute yourselves because there's feedback. So when we get there, we will deal with that. But at this point already, if you are working in advance, those are dealt with under bonds, and it relates to our joint estate. So we're not going to talk much about that at this point in time. It's coming up later. Right. So you've got your application to your disposal in terms of section 45, whether it's a 45(1) or a 45 bis. It depends on the situation. And that is, like, as I said, an easy one without any form to it or format prescribed to it. And you literally bring the application and you endorse the title deed, the holding deed, to that effect. You also have the option of bringing a Form E application, but it's kind of become used that if you have to your disposal Section 45, you will do for Section 45 or use Section 45. I'm going to show you an example of what the difference is between or what a Section 45 looks like. I'm going to do that now, so just one moment. I'm going to share my screen. Just one moment. I want to quickly find the example. Okay. Oh, wait, you're not seeing this. One moment. There. Okay. Can you see this? Yeah, you can see this. Okay. So this is an example of a Section 45 application. Okay. Yes, one page. There we go. There. Okay. So as you can see here, this is Section 45(1). This person has died in community of property, or he was married in community of property, and then he died. And then the executor was appointed, and here you have a situation where you are not the executor, but for instance, there's a company that deals with a chartered accountant, in this case, that is dealing with or is acting as the representative, or rather the executor of the estate. Why do I refer to representative? Only when we have the situation where it's an estate with a value of less than 250,000 Rand. Then we will have a letter of appointment issued in our favor, or in the executive, or not the executive, the representative's capacity. So he is appointed, he's the appointee in terms of Section 18, subsection 3 of the Act, the Administration of Estates Act, the AEA, okay, then we will refer to, instead of the letters of executorship, it will be a letter of appointment with the specific number issued by the Master of the High Court. Here's the details under which this letter of executorship was issued. So you've got this application being brought, preparation clause, not half page, open, my heading for my application, okay, and then I or we, the undersigned, he's the nominee of BizTech, in the estate of the late Cecilia Ann Anna du Plessis, sorry, acting under his letter of executorship, okay? And then obviously, again, we spoke about this in the last lecture, section 21. This is a perfect example of section 21 in practice. Okay, remember I said to you, when we have a joint estate, the general rule, the golden rule is you will add the surviving spouse to the executor. So both the executor and the surviving spouse has to bring the application, and both of them, cited as this, will be in, or not cited exactly like this, but this is what will be referred to in the recital, okay, in the recital of the deed, if we go the deed route, Form E. Okay, so Petrus, in his capacity or my capacity as surviving spouse of the late, estate, well, actually that estate shouldn't be there, that's actually wrong, of the late Cecilia Anna du Plessis, to whom I was married in community of property, declared that this property, again, look, there's no extending clause, is registered in the name of the estate and surviving spouse, who's now a widower. The surviving spouse is entitled to one half. That's how we refer to it. We first say a half and then one half. Share in the above mentioned property by virtue of marriage in community of property. To the late, again, estate can go out there. Can come out there, who died on the 16th of September 2018, and the remaining one half share in terms of the last will and testimony of the late, again, okay, take out the estate part, late Cecilia and Anna du Plessis, dated Amanzimtoti 14th June, subject to the conditions of the aforesaid will. And now, the majority of your wills will have that clause in it, which basically says that the joint estate, if the person marries again, the joint is the asset will not fall within the joint estate of the surviving spouse. So again, this is what I said to you before. If we have a will and there's conditions that we have to now create newly, we will refer to them in the power of attorney, or we will put it in our application, okay, because now this title deed is going to be endorsed to the extent that there's a condition that says it falls outside of the joint estate, and also it's going to be endorsed to say that Petrus Jacobus du Plessis is now the full owner of the full property and not just his one-half share. So now here we're saying the value of the above mentioned property is the sum of 82500. Now look, that is the full value of the property, right? But I'm not transferring the full property, hey? I'm just transferring a half share. So you, if you refer to the full property being transferred, then in your and its value, then in your power of attorney, not your power of attorney, sorry, in your transfer duty, you have to refer to the full value of the property as well. Okay, and then you have to add to this the value of the half share. Okay, so you would literally refer to the value of the half share as being 50% of the amount, and let's just make it, just for argument's sake here, what, 800 divided by 2. Let's make it, let's just quickly make it 440,000. I'm not going to do the maths now. So if this is the case, then we will also refer to the value, the half share value, and we will declare it in there. Okay, so we will declare that value, and we will refer to the whole value of the property as well. So here you can see the executor and the surviving spouse signs this. Okay, and then this is lodged with a certified copy by the master of the will. Okay, and you will also deal with your section 42 subsection 1 certificate. Okay, and we'll deal with that in estates. But important here to see is this is exactly what I referred you to in section 21. Normally we do this unless one of the 5 exceptions applies. Then I don't join the executor and the surviving spouse. Remember, I gave you 5 exceptions. So this is a simple application that you will bring, and you simply refer to it as this. That spouse, you explain the spouse receiving its 1/2 share by virtue of the marriage, and then the other half share of the other spouse being the 1/2 being vested by virtue of a testament, a specific testament, and its bequests. Okay, so this is what an application looks like, and this is a 45(1). So this is a section 45(1). This means that in terms of a interstate or in terms of a will, we would have the property vest in the surviving spouse. Now, important here, if there was no will, and if there are no minor children, then under those circumstances, the surviving spouse would receive the half share of the deceased spouse, and then that would be in terms of interstate succession. Then you will refer to the interstate succession being the section 1A of the Interstate Succession Act. Okay, so you will say by virtue of his marriage, and then the other half being by virtue of the Interstate Succession Act and its specific section. Okay, and that's why I said to you, please, you now already, since you are dealing with reading and preparing your legislation, I want you to now start preparing your actual act, the Administration of Estates Act and the Interstate Succession Act. You already have to have it summarized, and you have to understand that the causas will differ depending on a testament or a will, and interstate succession, and you have to be able to reference it as such if I'm bringing this kind of application or dealing with it in the particular scenario with its whether it's interstate or whether it's by will. I just want to see there's somebody that's asked a question. I'm just quickly coming back here. Just see. I'm just quickly looking at the chats, but I can't see who's asking a question. Okay, there it is. Can't see the example on the screen, only you. Can you not see the example at all? Can everybody see the example?
Yes, I can see it.
Okay, TD Malu, you saying you can't see the example? Okay, well, everybody is saying they can see the example, so I don't know what's wrong with your screen. Just check with somebody there, TD Malu. Okay, so thank you. So everybody can see this. So this is the difference between your formal deed and the joint estate. Okay, you in all likelihood will receive an application like this. It might be in terms of section 45 bis though, with a divorce order or a court order, depending on the situation. Okay, so but you'll use exactly the same format. Okay, except that if it's a section 45 bis, you're not going to deal with the executor. You'll have the court order referenced. Okay, and then also you're going to not refer to the will. You will refer to the court order. Okay, so easy enough this is really one of those situations where it's, like I said, money for jam, if you do get this kind of a question. So here you can see, again, what's important for you is that section 21. How do I use it? Okay, right. So how do I use it? How do I apply it? What is my exceptions? What is my general rule? Okay. So thanks for everybody that's helping Tidimalu with that. Yeah, hopefully that can be accessed. I will. I think there are examples under the estates module. So if you go onto eLeader and you draw all your different resources under all of the chapters, you're going to find that there are examples. In fact, there's quite a number of interesting ones there as well. There's one, if I remember correctly, Alan, you would have printed it already. I think there's one with the bloedige hand neemt geen erf. Did I upload that? Did anybody? Okay, well, I'll check if I uploaded that one. There was one that that was done a year or two ago, where the concept of the bloedige hand neemt geen erf, the bloody hand does not. Yeah, Alan saw it. It is on the where that principle of common law basically applies, and the causa had to be drawn to allow for that scenario. So we've really given you quite diverse examples in there. Okay, right. So as I said, section 45.1 is our estates. If you want to practice them at this point in time already, then today's example will assist you in preparing or starting to draft. You can start with that. And then you say, will we deal with causa when repudiation? Yes, we will. In actual fact, we're going to deal with the law that relates to repudiation specifically. Because there's a general misconception about when somebody renounces, if they renounce their benefit in terms of a will, what happens then with the asset? Where does it go? Does it automatically form part of the free residue, or doesn't it? And there's interesting facts and information that we can share with you on that as well. Okay, so the person that asked, I can't remember who it was at that point in time, who asked about the causa, and I specifically said to the person, just remember, you're going to be dealing with the section 45. You don't have to worry about the formal deed, because in the exam as well, they're not going to ask you to prepare a formal deed. They will want to see your capabilities in terms of section 45 to prepare the application. Okay, right. Now, for purposes of this, I picked this quickly to explain to you, not merely because of the fact that you need to start drafting your applications, and you can feel more comfortable with that when you start preparing applications as well, because we want to get you at a point where you're really, really comfortable with drafting. I also picked this for the simple reason that the more you prepare applications, the more likely you are to easily prepare any form of application. And also, there's two kinds of endorsements against the title deed. There's two kinds of endorsements. So these endorsements are applied for. You bring an application to the registrar. You lodge the title deed, the holding deed, the original holding deed. and then you request the registrar to endorse the title deed with a specific form of endorsement. Okay. Now, why this is important is to understand that there's two forms of endorsements in lieu of your application. The one is a factual, or the one group of factual endorsements. So what they do is they only record a specific fact. So whether it's a fact of legislation, the consequence of legislation, or a fact of a change in an error, etc., it could be either, but it's basically a specific fact, a factual endorsement that records a fact that amends, so to speak. And that's why I said amendment isn't the answer. When I said, what is a 45? An amendment wasn't what I wanted to hear. That's not the answer I wanted to hear, because not all applications has the effect of amending. Okay. Some of them records a fact. Some of them actually records transfer. So in other words, passing of ownership. Okay. And it's for this reason as well that I haven't fully responded to Enoch's, the advocate's question to comment on a document that he prepared, is because I wanted to also explain to you is that your title deed may be endorsed with a specific endorsement, which has the effect of passing of transfer. Okay. So a simplified explanation cannot really be provided for certain things as to alienation, etc. And I wanted to also introduce you to the fact that you can pass transfer by way of an endorsement. Point in case is, for instance, the section 16. Okay, section 16. We've spoken about that, where the state receives all of the land by way that's held under one title deed. Then I can bring an application in terms of section 16 to the effect that the title deed is endorsed, that the property under that deal, all of the property vests now with the state. Okay, so some of them passes transfer and some of them records a fact. And section 45(1) basically has the effect of passing transfer. Okay, and when we have title deeds, when we have divorce orders, or even orders in terms of which matrimonial property regimes are amended, then that has the effect of passing formal transfer. So in your application, you will always say the deed is endorsed to the effect that this person the specific person bringing the application is entitled to deal with the property as if though he has taken formal transfer of that portion of the land. Okay, so important factual endorsements as opposed to registration endorsements. When we do sundry and miscellaneous applications, then we will go more into depth with that, and maybe we'll just touch on that by the end of the lecture, because the applications as such as well, they form part of your drafting, and also your citations of your parties that we are dealing with now is exactly what we deal with in applications. Okay, so easy enough, the difference between an application and a formal deed of transfer, simplified, factual endorsements and registration transfers. Okay, right. I also need to upload, I couldn't find any, because I'm still having a bit of problems accessing all of my history of my documents for the same reason as I explained the last time. I only found one exchange transfer example of for sectional title, which is basically has the same application and same format for purposes of the cars are being drawn, and I will be uploading that onto eLeader as well. Right, so just so that you can see what that recital looks like as well. And that is irrespective of whether or not it is sectional title or freehold. It basically has the exact same form with here and there a change, mutatis mutandis. Okay, right. So if we continue now on to vesting clauses and the transferee, and now again I have to say is that on your e-leader platform, you have examples of vesting parties. So there's a summary of different vesting clauses for parties. What is the vesting clause? It is the transferee taking ownership of the property or receiving ownership of the property. And in this regard, I'm going to quickly move across a couple of matters, and then we'll just stand still at specific, more difficult concepts. Okay, so so an important, if you look at page 80 of your notes, you can see the notes here. So if you look at page 80, I'm just going to quickly go back. I need to get new glasses, it seems. All my screens are way too far from me. So we've worked with recitals, and as I said, I've given you a couple of versions of the different causa and the wording for different that you can apply for share of transfers. Right now, if we look at page 70, I think it's 74 or chapter 6. Chapter 6. It should be your page. Sorry, it should be your page 79. Okay, your page 79 basically refers you there to section 17, subsection 1. So that is the one that basically deals with the situation of your parties as your transferees, and specifically how do we deal with the marriages. Okay, so one of the things that you have to have proper knowledge of, because we keep on referring back to it, and even under our sundry applications, we do an application in terms of section 17, subsection 4. So you have to have proper knowledge of section 17, because it basically tells us exactly how we should deal with the different spouses and what is required for purposes of the citations. Remember, from the onset, I've said to you that if the asset falls within a joint estate, then we're always going to say John, or as the case is there, John Maria identity number and Joan Maria identity number, married in community of property to each other. But if that property is excluded from the joint estate, so it's excluded from the joint estate, right? Then we can't refer to it as and Sunny Maria identity number, married in community of property to each other. No, we have to state that it's excluded. It's been excluded. That property is excluded from the community of property. Okay, so important is that we also, depending on the situation, is we're going to refer either to a deed of donation or we're going to refer to a will. Okay, so depending on the situation, we might have to refer to a will of a specific person. Obviously, that will would have to be referenced. So we will refer to the person as its name and then the date of its will. And then if it's a deed of donation, the same there, the donation being made in terms of a deed of donation on a specific date by a specific party. Okay, because that's part of your citation. Why has it been excluded? You have to say the reason for that, unless your existing deed basically just refers to it being excluded from the joint estate, and that would be then your reference. I just want to see there's a hand up, and it is Miss Nkosi, MS Nkosi. Nkosi, you had a hand up. I don't see a question, but I see your hand is up. MS Nkosi. Okay, you've put your hand down, so it seems there's no question. Okay, so important, those citations. Remember, this is the vesting clause. Okay, so this is the transferee receiving. Remember now, I said to you, if I'm the transferee, I would, and I am married in accordance with the laws of, for instance, let's say, the Netherlands. Okay, because that's one that I'm dealing with at the moment. So if it's the laws of the Netherlands, then only one party, whether it's the husband or the wife, is purchasing the property or receiving the property, acquiring the property as such, the rights in the property, then we would refer to the person, its name, identity number if that's applicable, or we would just say born, because maybe he just has a passport, so we would have born and then the date, and then we would refer to the marriage as being the person being married, which marriage is governed, there's a spelling error, marriage is governed by the laws of the Netherlands. So if he acquires it, he receives it in his own name, but we reference the country applicable. However, if he transfers it, then we would need the assistance of the wife. So then we would go John Maria, identity number or born, married, which marriage is governed by the laws of the Netherlands, and duly assisted thereto by, let's say, Gertrude Marais or Maria, so it would be and duly assisted by Gertrude Maria as far as needs be. So as far as needs be, she assists the other spouse, or if it was her, it would be Gertrude Maria, identity number or born, married, which marriage is governed by the laws of the Netherlands, and duly assisted thereto by John Maria as far as needs be. Then obviously, because there's assistance, in your power of attorney, you would have to have both of them signing, because how can you assist if you don't sign the power of attorney? Is that clear to everybody? Just quickly checking if there's any, there seems to be a comment. Alan says, I have Andrew Evans, identity number, married in community of property to Kerry community of property, excluded by conditions contained of Will of Williams. Yes, there's examples in your the examples. Alan's example is basically regarding an exclusion in terms of a condition of a will. There's various examples in your notes. Okay, so just look at your notes. There's examples for you with regards to a deed of donation, etc., etc. Just to pause here for a moment. I actually took the time to combine the citations into first starting at the power of attorney, and then going on to the deed of transfer, the recital, and then going on to the vesting clause. So then you can see what the difference is between power of attorney citations, the preamble, and the vesting clause. Because remember, there's differences between them, and you can't just apply what's in the power of attorney verbatim, okay, to your deed. Right. So the parties married in accordance with the laws of a different country, when they sell, they alienate, they assist each other. They can either buy in one person's name or in both of their names. So here you would find the transferees in this situation where they are same-sex marriages. They have entered into a same-sex marriage. So again here, as we said before, is even if they are same-sex marriage partners, or if it's a marriage, specifically a marriage, it would be John Marie identity number. And then you have the other spouse married which marriage is governed by the laws of a different country. Okay, so simple here. When we deal with marriages governed by a law, remember if this is a country that is not South Africa, obviously, and if it's a marriage, their laws can be different. So you would have to refer to the marriage as being governed by another country. It doesn't mean that South African Civil Union Act applies. Okay, this is a foreign country who is who governs the law of that same-sex marriage. Okay, right. Very important. You have to specifically refer to the countries. Okay, here's a question. Counsel can be done by endorsing an existing title deed. In the same token, may you please clarify the position in respect of limited real rights? I'm going to ask you just before we break, you can ask that question because I'm not quite sure what you're referring to, but before we break, we can come back to that. Then the representative capacity we've spoken about before. Remember, this is the vesting clause. Even if the parents have assisted the parties, or rather the minor, even under those circumstances where the minor has been assisted, or they have signed the agreement on behalf of, then under those circumstances we're going to refer to that minor as just being a minor. So with our minor's vesting clause, remember, not preamble. This is the person that receives. The minor receives as a minor, identity number or date of birth, a minor. Okay. I always refer back to either a date of birth or an identity number. But as you know, since 2000, the children are automatically issued with an identity number. But you never know, there might be a situation where there hasn't been a certificate. I mean, I wonder if everybody's been issued with certificates of birth during the pandemic. They might not be. Okay, then our mental patients, remember in vesting clauses, remember if it's a mental patient, this person do not have status for locus standi purposes. In other words, it affects its capacity to act. So under those circumstances, because this is a mentally ill person, the person cannot really declare or deal with anything in his person. That's why that curator was appointed. And that's why we also refer to the party as a mentally ill person when it vests in him, so that when this person wants to now, or an attempt is made to alienate the property, first you have to look at his status and whether there's been a change in his status as previously having been maybe a mentally ill person, or he might have been recovered. So it cautions us to know that we have to have the right person then on alienation to sign the power of attorney, because then I'm going to go back to the citation of referencing in the power of attorney as a transferor. I'm going to refer to the curatorship and his capacity in which he was appointed by the court to act on behalf of this person. So if we transfer, it has to refer in the power of attorney to the person being appointed by a specific court on a specific date, etc. Okay. So our insolvent parties, we don't refer to the insolvent. This is his insolvent status. Remember, this is now when I'm receiving. This is not the case when I'm trying to transfer. Okay, this is I'm receiving, I'm the transferee. Then we just refer to the party as John Maria, identity number, unmarried if he is unmarried. Okay, So deceased person's estate of the late, this is investing. Remember, we're not vesting the executor. The estate is vesting. This is in those circumstances where the person bought, for instance, during his lifetime. So now then it would vest in that estate, in the estate of the deceased. Okay. If it's a joint estate, then it would be the joint estate of the person and his surviving spouse to whom he was married in community of property. That's what we always add, to whom he was married in community of property. Okay. Because he died, the spouse is now cited as unmarried, no longer married. Okay, because he died. So he's married, but I have to say, but she was married previously to this person. So that's why I'm saying to whom he was married in community of property. So this is what we refer to or reference when it's in community of property and there is an estate involved. Remember, this is only for an estate where in community of property applies. Okay, I'm not going to put in here to whom he was married out of community of property. Okay. In our legal entities, you can just look at the notes for that. Yeah, Alan, you're all right. I'm answering Alan's questions because it relates to citations, and that's what we are dealing with at the moment. That's why I'm saying let's just wait until a break, and then I can listen to other questions on endorsements, because we can deal with that at that point. Alan, yes, you can either choose widow or widower or unmarried. The same goes for a divorced person. It can either be divorced or unmarried. I have yet to find that a person insists on being referred to as divorced. There are, especially in the proper English in KZN, there has been situations I've heard from colleagues where one of the spouses would say, the term unmarried means I've never been married and I was married, so I would prefer to be cited as, for instance, a widow or widower. So it's purely a choice of the transferee. Incidentally, just to remind you of this, is the transferee decides in which language the deed is to be prepared. If the transferee wants the deed to be prepared in Afrikaans, then that's the case. I don't know if there's any software that allows for any other language than Afrikaans and English. As far as I know, the deeds registries are only processing deeds in Afrikaans and English. And I don't want to go into a constitutional law discussion about this. This is the Deeds Registry Act, and this is what we do. We jump through whichever hoops they require us to jump through in order to get our deeds registered. Okay, and please don't light up the WhatsApp group discussing constitutionality of the requirement of Afrikaans or English deeds being prepared. I'm only reminding you of the fact that your purchaser may ask that the deed be prepared, for instance, in Afrikaans or English, depending on the situation. It is now it's 22. Enoch, the question that you've asked about as transfers can be done, let me just see here. Transfer can be done by endorsing an existing title. In the same token, may you please clarify the position in respect of limited real rights? Clarify your question. What are you referring to? Because clearly you have a specific situation in mind.
Okay, isn't it that for transfer of ownership, you can either get a new deed of transfer or the existing one can be endorsed?
Depending on whether the Act allows for a specific endorsement.
Yes, in terms of those sections 45, 16 and all of that. Now,
yes, for purposes of a limited real right, you're going to probably hold a notarial deed for purposes of that limited real right. So, for instance, you'll have a deed of usurper. You have a deed. Okay.
Sorry, Marike. Sorry. Basically, what it is that for ownership, it will be either a title deed or endorsement, But for real for limited real rights, it will be a notarial deed, right? Now the issue is that what I wanted to also clarify is that because in terms of limited real rights, you have bonds and you have servitudes, right? So I guess notarial deeds will be for servitudes. Am I correct?
They are normally for servitudes, but a notarial deed is also in respect of exclusive use areas, real rights of extension for sectional title purposes, etc. So it's not just a servitude, because technically speaking, a exclusive use area and a real right of extension is not considered to be a servitude.
But in this case, a bond, a mortgage bond, being also a limited real right, will then be by endorsement.
You have to now distinguish between two situations. Is the property encumbered by a mortgage bond, and that mortgage bond is an asset in the estate, or whether it is a liability in the estate? So now the person that holds the mortgage bond, and we'll deal with that at mortgage bonds level, that person initially starts off with having a personal right, and then by registration, obviously, it's endorsed on the title deed, and it's also registered in the deeds office. If it's an asset, you will cede the rights of the asset in terms of a cession, which is then in terms of Form MM, and that can only be done by way of the Deeds Registry Act. If it's immovable property, if it's movable, you will deal with a notarial deed of cession. Sorry, a notarial deed. And when it comes to your servitude, you will cede a servitude, but it also depends perfectly on what your servitude is created. If it's a usufruct that which is normally the case, will only apply during the lifetime of the person. If the usufructuary then dies, that deed, right, whilst personal in nature, will be cancelled and lapses because of the fact that the person died. So it depends purely on the nature of your limited right, how you will deal with it. And as we progress along with the different kinds of servitudes and the different kinds of limited rights, and the different aspects to sectional title, we deal with each one of them in that moment as they are. But it's not a given that you will deal with a notarial deed of cession.
Okay, so basically, in summary, given the fact that a limited real right like a usufruct, right? Usually you would then, because I remember when we did the deed of transfers, you indicated can it be then be basically incorporated in the deed of transfer itself? Right.
What is the question? What is the question?
Okay. Let me summarize it this way. In essence, when we deal with limited real rights, am I correct in saying that one, it could be the limited real right can be obtained through registration on the title deed, notarial deeds, and then the what you call the endorsement. Those three modes of acquiring it. Am I correct in saying that, depending on the situation and depending on the nature of the limited real right?
You can create a limited real right either in the power of attorney, and then carry that condition that you created forward in your deed of transfer as a newly created condition. Okay.
Right.
If you created that in a notarial deed of cession, a notarial deed of servitude, then that will have to be dealt with by way of notarial deed of cession.
Okay.
And that does not fall within your preparation requirements. You do not prepare notarial deeds at this point in time. You will if you take the notarial exam. And to provide a general statement as to say, as you can transfer by endorsement a limited real right, I'm not going to agree with that, because it's not a blanket yes or no. And when we deal with servitudes, we'll deal with it at that point in time.
I'm not saying it's, for instance, if you look at the bonds, the mortgage bond that the bank holds over your property, that being a limited real right, it is achieved by endorsement. Am I correct?
No,
How is it
no.
achieved?
You
Is it
you register the mortgage bond in the
right?
Deeds Registry Act, in the Deeds Registry, and then the fact that the title is encumbered is just endorsed. So, in other words, my deed of title is encumbered by a mortgage bond. That is just noted as an endorsement against the title, holding title deed. That title deed doesn't have the effect of transferring a limited real right. It's encumbered.
Okay. Let's deal with this one offline.
Okay.
So, yeah,
Yes,
let's
that's
deal with
what
it
I
offline.
said before. It's unnecessary discussion. Okay, let's at this point in time, let's reconvene at 10 o'clock. So you'll have a nice 15 minutes so I can rewarm my tea that I've been trying to drink. So we'll be back at 10 o'clock. Okay. Thank you. Bye.
umuntu wo rudera khothe atshinga asemana judge
Ag weet nie ek my in my nee, ek wil die ander ene hê want hierdie een is hy lees verder. Hy's in my swart kassie. In my swart oeps. Okay, we can proceed. Right, so now we are going to go on to extending clauses. Remember, we spoke about extending clauses in the past. I've briefly referred to them. Mostly I've said to you there's a form TT and a form UU that applies or that we should use, or yeah, we should use specifically either form TT or form UU. Okay, so the gist, or rather the crux of the chapter 7 is regarding the application of form TT or form UU. So a lot of people do battle with this concept, and it's for this reason that it's dealt with separately, because it can cause confusion. Extending clauses are one of those things that really causes some rejections at times. And even if you have a really, really good paralegal or conveyancing secretary, they normally do ask you to specifically check the extending clauses, because it's just it's something that could be somewhat tricky. So if you grasp it at the onset, then it's easy enough to deal with in the future. So, as I said, you would have by now, having since I have been referring you to section TT and section UU, you would have probably just had a look at those two forms that we use. And you would have noticed that they are different. They are worded completely different from each other. So why this is important is it's with reference to section 22, as you can see with your notes. It basically allows for that situation where property is owned by a specific owner under a title deed. And what can we do, and what is allowed for purposes of ownership, and how to deal with it when we have more than one property, or even more than one share in property. So the basics of section 22 basically says is that if I hold under one title deed, and this also applies to sectional titles, so please remember, whatever you hear at this point in time, you apply it as it is to Form H in the Sectional Title Act. So if I have one title deed and that title deed holds IRF 101 and IRF 102, I would have those properties, those urban, described in its own clause or its own paragraph is the correct word. It would be described in its own paragraph, and then its conditions will appear also below it. And then the next IRF 102, in whichever township it is, that will be in a second or a further paragraph with its own conditions that applies to that IRF. So that's the general rule. I can own a property, more than one property under one title deed. Also, it allows you to then transfer either one of the properties or both of them by way of a deed of transfer. Okay, so I can use Form E then to either transfer IRF 1 or IRF 2 separately, or both urban. Okay, or both urban can be transferred by way of one Form E. Okay, so under those, because this is only for purposes of deeds of transfer, that's very important. So remember, I can have more than one property under one title deed, and basically I can then deal with either or, and I don't need to take out a certificate of registered title in respect of either of the properties. No, they are held under the holding deed, and I can transfer any one of them off to the other person. Here, I've just got to say, as a practical note, as a very simple practical note, that you should always look at when you deal with transactions in a nature of transfers, and its sectional title. Just a word of caution there. A lot of estate agents will only refer to the primary section, and then you will find later on that there is indeed another section which is reflected as the garage, even though it's not called the garage, it's just a completely different section with a different number. If that happens, then it's normally held under the same deed. It could also be held in two different deeds. But that garage normally is intended to be sold or alienated together with the section, the primary section. So even though your deed, your sale agreement, your deed of alienation, even though it may only refer to one of the sections, you have to take the time to do a deed search on the person in the deeds office. Look and check whether there is another section. Normally, you determine whether the section is a garage or something by looking at the square meters, because normally that garage is either 8 or 14 square meters or 22 square meters. Now, that normally indicates to us that that small kind of section is normally that garage. And as I said, the intention of the purchaser may be that, and the seller may be that they are transferring, or they are selling and acquiring the garage together with the section, the primary section. So then you have to correct, obviously, that sale agreement by introducing an addendum to include the second property. That's the first thing. And the second thing is you have to deal with that property in your transaction. So very important. Always check, especially with sectional title, whether there is another unit that is owned by the transferor, and what is the intention, because maybe that person also has more than one garage that's held as a section, and maybe he does not intend to transfer both of the garages. So we always investigate that, and as I said, you can't just go on based on the sale agreement, because the majority of the time you will find that the estate agent gets it completely wrong. And I've just got to just mention this, especially when we do sectional title. I had a call late yesterday afternoon from a friend of mine who actually said to me is that she's now so unhappy because in 2017 they bought an earth, and they made it very clear that they bought an earth, they want to build and they want to subdivide in future. And then she realized 4 years later that actually it's sectional title, it was a real right of extension. And now they are quite unhappy because they can't sell the property because they thought they had a freehold. Well, and freehold is not really the correct term, but they thought they owned an earth. Yeah, which is causing severe problems. So very important to make sure that parties that you deal with in a transfer, even if you didn't prepare the sale agreement, that they know exactly what they are buying. Okay, so for that purpose, we always do those kinds of searches. And then if we continue on with section 22, subsection 1, just to also note there that section 22, as I've said, that basically deals with our deed of transfer. That's the title deed, okay, the title deed as such. And we're not dealing with real rights as mortgage bonds, okay. We're not dealing with that under section 22, okay. There are situations where you can release a property or substitute a property under a mortgage bond, but that we will deal with under mortgage bonds. So always remember that the mortgage bonds, they are a separate issue or form of or part of conveyancing. However, you are not allowed to deal with the land without dealing first, whether that means you're cancelling, you are ceding, or you are substituting debtors, etc. You have to first deal with the property, even if you are releasing the property, part of the property, releasing the one of the parties, etc. You first have to deal with it. Okay, and that is why in section 45, just a couple of minutes ago when we spoke about that, I said to you, you're going to find that you deal with a Form W, a Form T, and a Form BBB. And you have to understand that there's different ways in which I can deal with a bond. But nonetheless, if my property is mortgaged, I first have to deal with the bond before I can pass transfer. And that is the general rule always. You are going to get questions where it has quite an elaborate factual scenario in your exam that will have deeds of transfer involved as well as the bond aspects. And normally, as a general rule, we use Form MM under bonds, unless the Act provides for a different form, as is the case with the Section 45s, the WT and Form BBB. Okay, so always remember that is I have to be able to differentiate between the different scenarios that I will use, either or these different forms, etc. Right, so important there, if you look at section 22, your co-owners, what am I allowed to do? Very simple is if I have co-owners, then at the end of the day, as co-owners, both of us, A and B, can transfer our full undivided shares to other parties, or even just to one other party. And we can do that by way of one deed, okay? One deed to two different parties. Very important we can do that. It's basically just the basics of conveyancing that is basically explained here, okay? If you look at section 24, you've just got to remember that if I have co-owners, they have an undivided share in the property. They do not hold a separate portion one or a separate remaining extent. No, they don't. They have co-ownership, so they hold it in undivided shares. So in the absence of anything to the contrary, if it's the parties have equal shares in property, we will basically just cite the two parties as such, and because we don't state the shares, it will be presumed that, well, it's not even presumed, it is proof that they each have a 1/2 undivided share in the property. Yes, they can go enter into an agreement, but that agreement is only inter partes, enforceable between the two of them, in terms of which, for instance, the one would use the western part of the property and the other one the eastern part of the property. Okay. Remember that that would only be between the two of them as long as they haven't partitioned the property as such. Okay. So then section 24.2 that basically deals with surveying the different shares, etc. And then obviously, do I have to alienate to another party or a completely different party if I want to do that? Depending on whether or not a specific portion has been allocated to a specific owner, then that owner can deal with it separately. Otherwise, as long as it's not been awarded to us or agreed to be imparted to a specific owner that was a co-owner, then both of the parties can then, up to that the point of allocating ownership to either of them, they would both pass transfer to a third party. Why is that? Because at the point of subdividing the property that is owned by two persons, then both of those parties will be co-owners of the remaining extent of the property and the portion one. And then both of them will be on will remain on the certificate. If they first want to transfer the remaining extent, they would take out a certificate for portion one of the earth, and then transfer. Both of them would transfer off the remaining extent. When we're doing just in a couple of pages from here, we're going to plot conditions and explain the difference, the different portions to you. Okay, so always remember, unless I specifically state that the parties hold in different shares, they are presumed to each hold in equal shares, and unless I have a situation where my fraction cannot be expressed in less than two denominators, then I'm going to end up using a decimal equation. Okay, so and that is a six-figure decimal representation of the share in the property. Okay, so Regulation 28 basically just refers to your registration division and how to cite the different urban. Remember, we have three different, well, some say four, but basically it comes down to three different property registers in the different deeds offices. The one is the township register. That's all the urban that fall within a municipality or a local authority area. Then we have farmland, which is part of your agricultural land that is held under the farmland registry. And then you have sectional title. And sectional title is in its own registry. So you cannot have a property in both the sectional title registry and the township registry. Okay, so what is the differences between these? It's the example that you have there. And again, I'm just going to point out that this description is going to be different in the Cape. Remember that the Cape province, Western Cape province, and as the Eastern Cape province, they will refer to the municipality as such, as city of Cape Town, for instance, and its division, which is normally its afdelingsraad, or the Afrikaans part for that, in whichever division it falls. You've seen in some of the examples that's uploaded on eLeader that it has a completely different citation, or not citation, property description. So the rest of the country, it will be 75 Oakdean Township. In KZN, it will be 75 Oak Dean. As I said before, wherever you write, you use the Deeds Office requirements in your province that you write. We did discuss it at the end of the last lecture, and I explained to Alan at that point in time that your examiners are the guys in your province, so you have to adhere to that deeds registry requirements there. Iglo is saying in the description of an earth, does it matter whether I say measuring or in extent? It doesn't matter if you say measuring or in extent. You can choose whichever you want. It's a personal drafting thing, as long as you refer to the extent of it as 500 and then in words 500. And then obviously cite if it's square meters or hectares or what the situation is. Okay, so again, province you are dealing with, that's how you refer to it. Okay, so your property description ends after the extent that it's reflected in. Remember that. You do not go on to your extending clause. Now, this is a situation where you have an agricultural holding. Okay, so that is in Afrikaans 'n kleinhoewe. Okay, so a plot as well. So here we basically refer to the holdings number, okay, and then obviously there is a name for those holdings. For instance, in this case, holding number 20, Zandfontein Agricultural Holdings, Registration Division, again, province of Gauteng, measuring or in extent 17310. And then in words, as I said to you before, if it's hectares, we go 1 and we write comma 7310. So 1 comma 7310, all in words, hectares. And then your farm, the farm normally has a farm number. Okay, now look here, this is holding number 20, an agricultural holding. Okay, holding number 20. Okay, here we have a farm that says a portion, or it could also be portion 1, a portion of portion 2. So this is a subdivision of a subdivision of the farm and its name, number 267. Again, measuring, this is 6 decimals. So again, 22,1031, 22,1031 hectares. Okay, so just to explain to you again here why I believe that that there is only 3 registers, is if we look at by comparison here, we have the earth and its township, and again here we basically have a holding, okay, as opposed to a farm with its number. Okay, a farm with its number. Agricultural land or farmland is in a separate registry. Okay, right. Always remember that as we've just looked at section 22.1, you have to break those different sections down for yourself and know and understand what it means. When can I transfer in one deed? If my deed isn't on my name is not under the deed. In other words, let's say John Doe owns Earth 101 and Jack Black owns Earth 102, and each one of them has a separate deed, then they can't transfer in one deed the separate properties that they own separately. No, you can't do that. You can only deal with the property that you have registered in your name under a specific deed. Okay. Right. So now we get to the different aspects of holding shares or undivided shares, specifically an undivided share in property. And we have to always make sure that if we deal with property that's held by more than one person and in a specific, I'm just checking for questions, it seems to be, oh no, it's done. Okay. And if we are dealing with different shares in property, then we normally can accept that it will equate to 100%. So the full extent of the property it normally equates to, unless it specifically only deals with, for instance, 5/8. So let's say, or let's say 3/4, 3/4, 3/4 of a property. If you do not deal with the whole extent, the full extent of the property in meaning, when I refer to extent in this case, I mean all 8/8. So in other words, the whole of the property. So in other words, if I end up just transferring 3/4 of the property, I can actually also do that. But then I have to refer to if it's held by more than one person, or if it's even held by the same person in 3/4 and another person 1/4, making up one, then I would have to state that what is the ratio in which I am holding or owning. When I'm saying holding, it means I'm owning the specific property. So if you look at the bottom of your page, let me see, 85 of your chapter 7, where it basically refers to the separate shares of the property. So where a deed includes more than one property, each property must be described in a separate paragraph, each paragraph being numbered. If I only have a portion of the land or own a portion of the land in one earth or one property, then I would literally refer to the property in its share that I hold it. For instance, in this case, one half share in earth 25 Oakland Township, registration division IR, province of Gauteng, measuring 850, and then the words. And then the other property that's also held under that same deed, Earth 123 Germiston, registration division IR, province of Gauteng, measuring 100 square meters. So I can then, if I own it under one deed, I can deal with it as one transfer as well if I am transferring it off. Okay, so this would be both of them is held under the same title deed number. Okay, so and then just remember sectional title. We will discuss that under sectional title, and remember that the presumption is if I don't state anything here, then it's presumed that I'm probably dealing with the whole property, and only if it's in unequal shares will I ever have referred to the half. Or any fraction for that matter. And then when I only have ownership of one half, then I will, in a property, then I will always refer to, when I transfer it off to someone else, I will always refer to the size of my portion of ownership. And when I say portion, it's only for proprietary rights. It's not meaning it's a portion like in portion 1 as a defined area. This is an undivided share. Okay, it's not a specified. It's a specified portion. Okay. Then much of what we've said here up to this point is just dealing with those fractions and fractions as opposed to your 6-figure decimal, and there's your regulation 30. Again, we've now passed over section 30 by reference of this. You can go and look at the section in the regulation, in the Deeds Registry Act, and go and summarize it for yourself and make sure you understand and know it. Then we finally get to the most important part for your purposes, and that is the extending clauses, and that's that form TT and UU. Faith asks for explain the fraction of share description in terms of regulation 30. I don't get it where A owns 1/8, 156, 1/7, 1/2, and 1/12. Okay. Faith, ask your question with more detail. Are you transferring off all of it, or what are you doing? Or do you want to know exactly what the situation is for all of them? Okay, so I'm just going to assume that Okay, okay. So Faith's question is basically the following. She says, regulations, how should she deal with A that owns 1/8, 1/56, 7/112, and let me just get a calculator so I can make sure. I haven't been doing math out of my head for a very long time. 7 divided by 112. 0625. So that one is going to be a fraction. So that seventh of 112. So 112. That's going to be a decimal. 1 over 112. No, you can't do that. You can't deal with the 7112. That's going to be a decimal, and that's going to be a decimal. So 112 and 712, 712 and 112. Those are all going to be decimals. 1/8 and 1/56. Those are going to be in fractions. And then you don't give me enough information, Faith, but I'm assuming that this A is holding all of these properties in all of these fractions in different properties. So that's why I asked clarify what your question is. So I'm assuming A holds different properties. Okay, your 86 and mine's 86 is different, so I'm going to address it when I get to your page 86, which is probably then going to be in 2 or 3 pages. So hold on to that. Yeah, it's from the books. I'll get to it because my pages are differently numbered than yours. So we'll get to that just now, okay? So just hold on to your question. So again, the extending clauses, important. Sorry, let me just get back to that. Extending clauses, regulation 26 you need to look at, okay, and important that you understand that difference between form TT and form UU, okay. Now the general rule, and I want to okay, Alan, I'm going to get to those fractions and stuff just now, okay. I'm going to get to it just now, okay. It's like I said to Faith now, the moment your common denominator exceeds two numbers, we are going to, you can't express it as a fraction. You have to use the 6 decimal, etc., etc. Okay, but we're going to get to that just now. I'm trying to follow the sequence of the notes because there's always a request that I must follow the layout of the notes. So that's what I'm doing. So back to this, the extending clauses where I was. I'm just trying to just reorganize my thoughts here. Form TT and UU. Okay, what I'm going to do here is I'm going to show you a diagram. Just one moment. I'm just going to show you a diagram, a subdivisional diagram. Just a moment. Okay, that's not going to work. That's sectional title. Just one moment. This one, just bear with me that I just want to have it. Okay, let's choose another one. Okay, now I'm just getting sectional ones that I've saved. So let's just quickly look at a different example that I had. Okay, let's choose the one in your notes. Maybe that, I think I saw one in the notes, so let's just use that one. I'm just quickly scrolling to the chapter that has actually plotting of conditions. Not that, not that, not that. I just want to find one that's, I think it's in the notes, there's a specific. Oh, no, with my luck, I'm not going to find it. So let's just bear with me for a moment. I'm very sorry that we are battling to find my diagram. I'll find it just now. Yep. Okay, I'm going to use this one. Can you see this diagram? This is diagram 2217 of 1997. Can you see this? I'm assuming you can. Let me see if nobody, no, you guys are saying no. Okay, it's in the red thingy to me, but I'm going to see why. Oh, it's because I didn't share it. Sorry. Now I'm sharing it. There. Okay, now you can see it. Okay, so this is a subdivisional diagram. Okay, so in other words, yeah, you can see it. Thank you very much. Okay, so everybody can see it. So this is a subdivision. You can see this little square. Oh no, not square. Triangle. Triangle. This triangle has been subdivided off of a different earth. So this A, B, C, A. I'm specifically saying this A, B, C, A, closing it, because we close off our component so that we know it's this whole earth. Okay, so this earth or this portion has been subdivided off of earth 970. Okay, so how do I know what we are dealing with? Okay, so the first thing, because this is an approved diagram by the Surveyor General, there you can see that it's been approved. So this is what we lodge with our applications at the end of the day at the deeds registry. Because it's been approved, and it's normally my registration copy or my original registration diagram. For purposes of registration, it has a stamp on it that says it's the copy, or it's the registration diagram for purposes of lodgement, right? So here, as I said, we know that it's already been approved, and now we can look at what we are dealing with. So there's a servitude note here, okay, and this servitude runs along this dotted line. So A, B, back to A, capital B, there's my boundary line, okay, then B to A to B, okay, and then we're going to close back to A because that's that whole area there. So it says that represents a sewer and drain servitude 3 meters wide. So this whole area here is 3 meters wide. This is one of the situations where if my servitude, I'm just mentioning this in passing, remember it for application later on. If I have a servitude in equal width along the whole boundary line across the whole earth, okay, or portion, then I don't necessarily need to have a servitude diagram. I don't need a servitude diagram. I can describe that servitude in my power of attorney with reference to its width and the components, the boundaries that it's running along. So if it's along a line in equal width, okay, then I can describe it. I can create it in my power of attorney and carry it forward. I don't need a diagram. Everything else that's not of equal width and running around along one boundary line, the whole boundary line, mind you, I would need a general plan. Oh, not a general plan, it's a servitude diagram. So a diagram reflecting that servitude. But this is one of the exceptions with servitudes, that I can describe it without needing a plan, a diagram, sorry. I don't know why I keep on saying a plan today, a diagram. So if it was, for instance, a general a servitude in general terms, then also I don't need to lodge a diagram. So we'll get to that when we do servitudes. It's quite nifty. So that's now my portion that's being subdivided, and it is subject to that servitude along this boundary, 3 meters wide. This is an S&D servitude. That's what, if people refer to an S&D, it's a sewer and drain servitude. So now we know also that figure here, ABC, that actually is 120 square meters, and it is portion 6 of Earth 970 Woodview, and it's FU, so it's in KwaZulu-Natal. Okay, so that is now my new portion. Because I've just created this portion on the subdivisional diagram, which of the forms do you think am I going to use? Form TT or UU? You can quickly drop me a note in the text box. Form TT or form UU? Anybody, take a chance. I'm going to explain it in any way now, so it doesn't matter. The question is, which form am I going to use? Form TT or form UU?
The question
in the creation of this of the portion. You can pop it in the text box, it's fine, but for portion 6, which form am I going to use in the extending clause? Form TT or form UU?
So this is a creating of a portion for the first time.
Yeah, that's why we have a subdivisional diagram that I've just explained.
So okay, I think it's going to be a TT, the first one, the TT, I think.
Yes, it's a form TT. Okay, so it's form TT. So how do we apply it and why do we use it? So it's a completely newly, everybody that said form TT, you are correct. I see everybody said form TT, so you understand the principle. Thank you. I can see that you understand it. Thank you, everybody. So form TT, why do we use form TT? The first reason for this is we're going to use this in respect and look at the heading of the form TT. So page 82, page 82 in your legislation bundle, your legislation book from LEAD, which is the form and the act that you are going to get in the exam, which is why I'm saying do not go and buy or look for a simple booklet that has this form and the regulations, which is the forms, and the actual act in it. It's in your legislation book. So use your book, okay? So form TT, if you look at the heading of form TT, it very clearly says that from this form is for an extending clause for a title deed in respect of an entity of land not previously registered. So if I've just subdivided Earth 970 in Woodview, if I've just subdivided it into a newly created portion 6, then portion 6 has never been created before. it has never been registered in the deeds office. Okay, so clearly under those circumstances, I'm going to use Form TT. So this is when I start with a completely new part of or portion of land. So, and it's not just a portion, when I consolidate as well, it will be a completely new unregistered property. So I will also use this if I consolidate, not just when I subdivide, okay? So under this situation, it's very clear there that it says it has all the parts of a property description before it, and then it goes on and it goes into the extending clause following on from the property description. And that's the one that starts with as will appear from the next diagram, because this is an A4 diagram, so we are going to annex it to the title deed. So my extending clause of my draft title deed is now as will appear from the annexed diagram, and this diagram is diagram SG number 2217/1997. So my extending clause in my draft deed, if I am going to take portion 6 of Earth 970 woodlands, if I'm going to transfer that to another person, I am literally going to use the property description, which is going to say portion 6 of Earth 970 Woodmead. And then if I am in Pretoria, I'll say township. If I'm in KwaZulu-Natal, I won't say township. Registration division FU, province of KwaZulu-Natal, in extent 120. How do I know it's 120? Because it says it's 120 square meters. Okay, and then I'm going to go on right after that. I'm going to say, as will appear from the next diagram, number 2217 of 1997. So as will appear from the diagram, SG number 2217 of 1997, annexed. Okay, annexed. Okay, and then basically I'm going to refer to the actual title deed that it's being held under. Right, so what was it held under? Let's quickly just check here. It says here that the title deed number is here. Can you see where I'm circling with my arrow? The title deed, I hope you can see where I'm circling with my arrow. Let me just use a highlighter or draw. Yeah, let's draw that. Okay, so I can actually draw. Yes, I can draw. So there's my as will appear from SG number, diagram SG number 2217/1997, annexed, okay, and then my property is that's the extent. There it even tells me what's my province, okay, and I then literally continue to the holding deed. So if I had to look at the wording as it is in Form TT, again, if you're going to leave this until the day that you have to write this exam, and now suddenly you're looking at Form TT and now you're completely freaking out because now you just see a bunch of words, but you don't know how to use it in your draft deed, then you are going to have a problem. That's why you are required to prepare your documents and write them out in advance so that you can familiarize yourself with the forms. So it will start, as I said, I'm just putting my glasses quickly back on. We're going to basically say, as will appear from, as per the wording of the deed, as will appear, the Form TT, as will appear from the next diagram, SG number 2217 of 1997, okay, and that is obviously the next diagram, and then I continue on, and I'm going to now refer to my holding deed. So under those circumstances, I will use this holding deeds number, which is the one at the bottom middle block, because that is what it was initially held under. So I will end off by saying or referring to held by deed of transfer number T2144/1990. So simple wording here. Depending on what the situation is that it was initially held under, it could be held under a certificate of title. So in other words, I may have consolidated a property and then I'm subdividing it after I consolidated it. Under those circumstances, I would take out a certificate of registered title for the consolidation, which is a CCT, a certificate of consolidated title, a title in terms of section 40 of the DRA. I literally then use the CRT that I prepare as my holding deed. And I then refer to not a holding deed, but I will refer to that property being held under certificate of registered title with its number. Okay. So with reference to the wording that you find in your Form TT, you will see it says disclose whether a deed of grant, a deed of transfer, or certificate of title is what you hold the property on under, and that will be then followed by the number of that title that you hold it under. So just again to assist you with Form TT, as will appear from either a diagram or a general plan. Here we have a subdivision, so we're dealing with a diagram, as will appear from the annex diagram, SG number 2217 of 1997, okay? And then simply after that, and held by my title deed here, title deed number, deed of transfer number T21444 of 1990. That will be this extending clause, Form TT. Okay. Now, let's use this. And now, this same property, this portion 6, we are now going to transfer portion 6 after we transferred it with reference to this diagram. Now we are going to transfer it again to another person. So in other words, we held this, let's say I'm making a note here, okay? A was the owner, he created this, he subdivided this portion 6. Then A sold it to B. Now B is going to sell this property after he received portion 1, and it vested in portion 1, and we used in the extending clause Form TT, which said at the time, as will appear from a next diagram, number SG number 2217 of 1997, held by deed of transfer number 21444 of 1990. Now B is going to transfer it to C. Okay, so yeah, that's not a very nice C, but yeah, that's a C. Okay, that's a C. Okay, now I'm making it worse. Let's make it. Okay. Oh, no, that one, draw. Okay, C. Okay, oh, horrible. C. So when I transferred it to B, it vested with that extending clause. Now B is transferring it to C. What would my form look like when I transfer it now? Am I going to use Form TT or Form UU? Drop it in the box. Are we going to use Form TT or UU? No, you're wrong. The title deed won't rest in peace because you are still holding the remaining extent under the holding deed, so it cannot be exhausted and it can't be dead. No. You're only transferring off a portion. You're saying, I guess the certificate of registered title in respect of the sold portion will rest in peace after transfer. Only after transfer to another person will that title deed be exhausted, but your remaining extent that it was created under is still held under your holding deed, and as such it cannot be dead and it cannot be exhausted.
Okay,
Okay,
maybe
so
what I need maybe if you can clarify that the certificate of registered title,
yes,
is it
that's new title deed.
is it in relation to the portion or the remaining extent?
Only the portion.
Is
The remaining extent is always held under the holding deed, always.
Yeah, but what I'm saying, Marike, please understand me here, is that because the portion, as soon
Was
as
transferred, yes.
as soon as it gets transferred to the next person, then that
Then that
certificate
will be exhausted and dead.
Yes.
Yes.
That's what my point is saying here, to say, I guess the certificate of registered title in respect of the sold portion will rest in peace after transfer. That's what I'm saying.
Okay, only the certificate, yes. Only the certificate in respect of portion 6, the remaining extent remains under your holding creating deed, the original holding deed. Okay, so important here now, A to B from B to C. Now, I see here, Igla, you said UU because it's already held under a title deed. I see the majority of you do grasp this concept. You all have said UU. So under this situation, now I'm going to employ the wording of form UU. So now am I and I just want someone else to also give your input other than the normal people that normally talks. Tell me how you will start with form UU. Igla, how are you going to start with form UU? Igla? Igler Bear or Bara, I'm not sure. Igler Bear. How are you going to start with your form UU? Igla, are you there, or should I mark you as not present for the whole lecture? Okay, so Igla is not there. Shimon, tell me how you are going to start your form UU. Shimon, are you also not there?
I'm here.
Oh, are you? Okay, let's start. Yes? Tell me
Yeah.
how you're going to start form UU.
To be honest with you, I don't know. I have to look at the form. I haven't looked at form TT and UU. The only reason I said UU was because I knew that the TT was in respect of the first portion, basically.
Yeah. Okay. No, that's good. That's an honest answer. So let's look at is it Cleland Peters? Cleland Peters or Sleelan, or I'm not sure. Yes.
Sleelan.
Oh, Sleelan. Okay, Sleelan. Yes,
Yes.
nice, interesting name. Yes.
You would give the full property description.
Okay, but remember now, you must stop there, because in the exam, if they say to you, draft the extending clause, and you start with the property description, they're going to mark you down, okay? Because the extending clause
Okay.
starts after the property description, hey?
Okay.
Okay, remember that. So you start now immediately with form UU. Go.
Okay, I'm a bit lost now. After form TT, then you do form UU.
Yes, you use it, yes?
Okay, so then don't you then again just give the full description?
Normally, okay, remember when we break up our title deed, we have the property description and then we have the extending clause. The reason
Okay.
why I'm pointing that out to you is while the form UU refers to the property description that follows onward to the extending clause. If they
Okay.
ask you in the exam to prepare the extending clause, then you do not insert the property description, because if they said prepare the property description and the extending clause, you would use the property description and the extending clause.
Okay.
A lot of the questions you will find in the exam papers, if you go through the exam papers, you're going to find they ask you specific aspects of the deed. Instead of saying prepare the whole deed, they will say just give me that clause. That's part
Okay,
of
so
the.
then would I be correct in saying that you would then start by saying firstly transferred and then you state the size, or the size would already be there?
Okay. basically, if you look at the first line of Form UU, you'll see that there's actually nothing in that line, because it basically just shows you where that your property description is going to be the top part. Then you are right. You start with first transferred or registered by. Now my question is, which one would you use?
Registered.
Yes. Why?
Because the property was already registered.
Exactly, because you've registered. No, come back. Step back. Why do I use registered?
Okay, if I am correct, we transferred it from A to B.
Yes.
And it was registered, am I right?
But that's not what this refers to.
Okay.
Right. It was registered in terms of a CRT, Certificate of Registered Title.
Okay, now it makes
So
sense.
my title deed. Now, no, that is such a fantastic thing that you said, because I don't know if everybody understands it. Okay, so Slelen, you perfectly right there with what you started. It is registered, but not for your reason.
Oh, okay.
It was registered because it was created by way of a certificate of registered title. If it was already held under a deed of transfer, then you would say first transferred. Can you see the difference? It's registered
Yes.
because my title deed is a certificate of registered title, and not a deed of transfer. That's why we use the word registered, first registered, and not first transferred.
Okay, Mariki, can I then just ask another question?
Yes.
How do we then differentiate when the property is registered in terms of a certificate of registered title? When do we do that?
Only when you have created it by way of a subdivision or a consolidated title, and it's a certificate of registered title. Actually, it's not just those two, because when we do CRTs, you're going to see all the other CRTs that we can take, can apply for. If there's at all a certificate of registered title that the property is held under, we will,
Yes.
and it's newly created, and it's new. Listen very carefully. It's newly created, and it is a certificate of registered title that I hold it under, that it was registered and created under. Then I use reference to first registered. Yes,
Okay.
because my title deed is a certificate of registration. I shouldn't go into too much detail at this point, but those of you who are working forward, and it's important to already now know, what is a certificate of registered title, a CRT or a CCT, as opposed to a title deed? It is a substitutive title, a substitutive title. So what does that mean? It means that my certificate of registered title is going to stand in the place of a deed of transfer.
Okay, no problem. Now I understand.
Okay.
Thank you.
And because Leland, because it is going to stand in the place of a certificate or a deed of transfer now, and I created it now, that's why I say it's registered. And it's only once I have that certificate, that CRT or that CCT, that certificate of registered title, if I have that, then I know it's first registered by way of certificate of registered title. Otherwise, it's always first transferred, because there's a title deed number. Whether it is, for instance, a certificate of certificate in terms of section Form F, where we have partition. If it's a partition transfer, it's still going to be a deed of partition transfer, so it's still going to be first transferred.
Okay.
But if I have a certificate, then it is first registered. It's newly created. It's a completely new certificate that now creates those rights, and it's registered as such. So you do now understand when do I and why do I use transfer, and why do I use certificate, right, Leland?
I do. Thank you, Mariki.
Okay, so now we go on. So we're going to say, following the property description, first registered by certificate of registered title, okay? And then our certificate of registered title is still going to have a T number. It's going to have also a T, because a CRT is stamped also with a T number. like a deed of title, because it is a substitutive title. So let's make up a certificate of a registered title number for B. B is holding it now under T1 of 19. Whoops, I'm trying to write with my mouse. I hope you can see that. That is not normally my writing, but yeah. C, we are now holding, is holding the portion 6 under the CRT, and the number is T1 of 1997. So it will say first registered by certificate of registered title number T1 of 1997, okay, with diagram number 2217 1997 annexed thereto. And then that's where we stop. Okay. So first registered by certificate of registered title number T1 of 1997, okay, with diagram number and then the number of the diagram annexed thereto. If it was a general plan, we would refer to the general plan number. Okay, easy enough. Now we are going to go on. Now C is now transferring to D. Okay, so he's now transferring to D. Right. Now C is holding this, B held it by way of T1 of 1997, and now he is he's transferred it to C. Okay, by formal deed of transfer. Now C is holding the portion 6 under T. Let's make it 2 of 1998. Just that's an 8. Okay, right. So now what do we do? How do we refer to it? Anyone? Sorry, let me just Petsai Marimba. Your question is a newly created portion was registered for the first time and got a certificate of title. When we now transfer, we say registered because there hasn't been any transfer, any deed of transfer before. Okay, you say you understand now. Okay, that's right. The thing is once I've created a certificate of registered title, right, then I am never going to refer to it as first transferred, because when I first created it, it will be a certificate. So it will always be first registered by deed or by certificate of registered title number. Okay, so okay, I'm going to pick somebody from the attendees. I'm just going to see who is there to continue with this one. Chantal Reddy. Can you unmute yourself and tell me how we're going to deal with it now?
Morning, Marika.
Morning.
Hi. Oh, is it? Yeah. Okay.
Yeah, no, morning.
There was a lot of information to digest. Is it gonna be similar to the previous one where we said first registered by certificate of registered title, and you referred to A when it was first registered?
Okay, remember when A registered recorded the subdivision,
Yes.
we took out a certificate of registered title, and
Yes.
then that certificate of registered title basically meant that we now are capable of registering it in or it was then registered in the name of B. So because under this situation where we subdivided into this, we literally created it as such. The subdivision was created and we transferred it in terms of the CRT where it was initially created under that, or initially held under the holding deed. So because we started with saying first registered, so we're going to continue on with first registered, okay, and with the reference of the CRT. Now we have to distinguish between two other situations. Petsasai, your hand was up. Is it still up or?
Hi, Mariki. Say yes, it's still
Yes.
up. So I was
Yeah.
going to say, okay, so first registration. Okay, so a portion has been newly created. It was never
Yes.
there before, where we have subdivided a bigger portion and we created a smaller portion in that portion that has been newly created. So when we describe it, we say registered or first registered.
Yes.
Okay, then
Yeah,
when
because it's a certificate of registered title that you hold it under.
yes,
Yes.
certificate of. Then now, when we want to transfer it to the next buyer or purchaser or whoever it is, we are going to describe it as first registered. But now, when we want to further transfer, then we are going to say first transferred. And
No.
then when, okay, so
No,
maybe I'm not getting it
Percy,
right.
with that, yeah. We're only going to say it first transferred if we hold it by way of a deed of transfer. But because we hold it in terms of a certificate of registered title, we can't say it's a deed of transfer because it's a certificate of registered title title in terms of which we created it.
Okay, so I think I've missed some parties there. Maybe you want to go back to the ABC so that you can make reference to the ABC.
Okay. So A is the owner of the whole earth 970. Okay.
Yes.
Then he cuts off a triangle. Okay. He cuts off a triangle, sorry, here. And that is portion 6 and it is 120 square meters.
So that is first registered under certificate of title. That's what
yes,
that's how we are going to say.
We use the subdivisional diagram. We file that, and we and that is created then and recorded in the deeds office as a portion, a subdivision, as a CRT. We are going to describe it because the certificate of registered title is basically our form of a proof of title at this point in time.
Now we want to transfer from B to C.
Okay, then we are going to basically have, because it was created, so A is going to transfer it to B. Once, as he or she, A is transferring it, it's going to be a completely new portion of land. So it's going to be as will appear from this diagram. Okay, and then we're going to use as will appear from diagram. Okay, held by a certificate of, or rather, we're going to say held by deed of transfer, the holding deed. Okay, and that holding deed is this one. Now, if now we can assume that we took out a certificate of registered title, so then we're going to say first registered in terms of certificate of registered title with the number. And that's T1 of 1997, okay, with diagram annexed, okay. That is basically where my basis of my form UU is now used. Do you understand? We started with A to B using form TT, because we had a portion of land which is newly created, and that's why we go as will appear from diagram number SG number 2217 of 1997, held by deed of transfer, this one. Then we created this and we say it's a CRT in this situation. So now we are going to say first registered in terms of certificate of registered title T1 of 1997 with diagram whatever next. Okay, now we've got to look what are we holding it under at that point in time. Then we're going to refer to held by deed of transfer T1 of 1997. Yes, those who are answering held by deed of transfer 1 of 1997, you're right. Now, if I transfer again to C, that's where my holding deed will be 1 of 1997. But now if C transfers to D, he's now going to say again, first registered by certificate of registered title, number whatever the holding deed or holding certificate was, let's say T1 of 1997, and then we go on with diagram SG number 2217 of 1997, okay, held by deed of transfer. Oh no, not deed of transfer. Certificate of registered. Certificate of registered. No, sorry, it's a deed of transfer. Sorry, it's deed of transfer 2 of 1998. I'm getting myself confused with my numbers here as well. So my first registration will always in my form UU will always be first registered because it's a CRT. After that, I'm transferring it. It will be held by deed of transfer and not a certificate of registered title. Do you understand that? We only got to this point. We didn't go on to D before the questions came up. So you haven't heard this before. You would have A transferring to B, a newly created, as will appear from diagram SG number next, held by deed of transfer, the holding deed, the original holding deed. Then from B to C, I'm going to transfer. I'm going to say first registered by way of certificate of registered title with its number, okay, with a diagram next, okay, held by my holding deed, okay, which is the holding deed in terms of which B acquired. So then when I go to my further transfer, I'm going to refer to the deed being held under, or rather the property being held under a deed of transfer 2 of 1998. So then when so in other words, every time I change ownership, then the reference to held by deed of transfer becomes the previous deed of transfer. Okay, is that clearer? We're gonna practice a lot more with reference to these extending clauses as we go along. Is it clearer? You keep referring to a diagram. In this regard, I want you to always read the notes to your forms. If you look at your forms, you're going to see it says no mentions needs to be made of a diagram or plan or number of a plan if it wasn't mentioned in the prior deeds. And it says they choose, is it a diagram or a general plan? You can't have both, but you have to know, is it a general plan? It's got more than one perp on it, etc. And then I've got to say general plan. And then it says if it's not annexed or filed elsewhere, the extending clause must refer to the first title with the diagram relating thereto. So I'm always going to refer to the first title and its diagram, unless the previous title deeds never referred to a general plan or a diagram. I choose if it's diagram or general plan, and then if it isn't annexed to the first deed, but it was filed somewhere else, then I have to still refer to that first diagram. And then your last note there is the property is still held under a first title deed. The necessary adaptation must be done. What does that mean? That means if I have a situation where, say, for instance, the property was now created and say the person to transfer, let's call it John Doe. John Doe now holds it, and it was initially transferred to him by way of, let's say, deed of transfer, then under those circumstances, we would say first transferred by deed of transfer number, let's say 12345 of 2002. And then you go on, and if you have a diagram or a general plan, you would refer to it, but then you'll also say, and still held by deed of transfer. So in other words, I'm going to say first transferred and still held by, by deed of transfer number with diagram annexed. Oh, sorry, I'm losing my voice. Moment. Okay. Right, sorry. So as I said, if I transfer it and it's still the original title that I'm holding it under, it's going to be first transferred and still held by deed of transfer, whatever, with diagram or with general plan annexed or relating thereto. I'm going to show you practical examples of this, but I first needed to show you what the differences are here with regards to your different Form TT and UU applications. Okay, I'm going to just quickly erase these. Okay, and then I'm going to go back to, okay, so just first showing you that this is your deed, your diagram. Here you have a consolidated diagram. So now that triangle is being included into another property. It's being consolidated with it. There's your diagram, your consolidation diagram number, and this is a newly created Earth 1518. See, it's a completely new created property. Okay, let's quickly look at these answers and hands up. Let me just quickly see which is which here. Go to the chats. Let's quickly see. Let me just see where the questions are. Okay, Chantal, you okay now, right? Can you please repeat the extending clause from B to C? I will do that. I'll also give you a new example. And then EN, I think it's Enoch, yes, you have a question?
Yes, I have a question. The example that you just presented, it's an example that involves a certificate of registered title, right? Now, when you look at the example,
yes.
The example on page 86, the extending clause.
Yes.
In that example,
yes,
there is still subdivision, but it seems like a certificate of registered title is not involved.
Yes, those would be the situations where, for instance, remember, I said before in one of the lectures that you are not obliged to take out a certificate of registered title. When we do CRTs, we explain to you exactly when you have to, when is it compulsory to take out a CRT and when it's not compulsory to take out a CRT. So the first matter that I wanted to explain to you is we assumed that we had a certificate of registered title taken out. Okay. Now, when is the rule that you have to take out? I'll deal with it now so that you can just follow on and sharpen in additional skills in a later stage. Mm-hmm. The rule says that if I am not first transferring the remaining extent, then I don't take out a CRT. I don't have to take out a certificate of registered title. So in other words, if I'm going to subdivide my property, I've got portion 1 and I've got the remaining extent. If I want to transfer off the portion 1 first, then I will simply transfer it from the deed of transfer without taking out a certificate of registered title first. If I want to deal with the remaining extent first, so in other words, I want to transfer that first, I must take out a certificate of registered title for portion 1 first. Because that's only going to be dealt with when we do certificates of registered title, subdivisions and consolidations. I wanted you to now already see that there is a difference between if I have to say first registered because I take out a CRT, and when I do not take out a CRT when we use the deed of transfer. So technically speaking, yeah, if I retained the remaining extent, I would have been able to simply just transfer portion 6 off and refer to it as the holding title being the title deed in terms of which it was originally created, which I used as the as will appear situation. But it does not necessitate the fact that I took out a CRT. I could have just as well said with those examples from A to B, B to C onwards, I could have said it's a deed of transfer because at the end of the day, I didn't have to take out a CRT. This example that I used based on what I gave you now is purely to assist you to already at this point in time now know that there is a CRT. And once I have a CRT, I have to say registered, because what is it worth that we know that there's two forms of two forms for extending clauses, TT or UU, and you do not understand why we differentiate between first registered and first transferred.
Okay, no, it's the answer is very clear. Thank you. But now the last one, just the last one.
Yes.
Assuming that you meet a client who subdivided their land and they still own the remaining extent, and they also still own the portion, and they also have a certificate of registered title. So in that case, as a conveyancer, will you have a choice as to whether to proceed on the basis of a certificate of registered title or to proceed on the basis of just the title deed?
Okay, what you are saying is you're saying they subdivided, they have a CRT and they have a deed of transfer.
Yes.
So which portions do they have a CRT in respect of?
They have a CRT in relation to the portion itself. And
so there's just one portion and they took out a CRT for that?
Yes, in other words, when they
So in other words, what did I tell you about what is a CRT? It's a substitutive title. It goes and it stands in the place of the deed of transfer in respect of only that portion. So if they have a CRT and the parties come to you and say, I've sold portion 1, you have to transfer portion 1, then you do not have a choice. You have to use the CRT that was issued because it is a substitutive title. It has come and stand in, it's now standing in the place of the deed of transfer in respect of portion 1 that you are now transferring. You cannot choose whether you use the deed or the certificate.
And if they haven't sold anything, they still have everything, the extent and the portion itself and the CRT. So in that case,
firstly, it's not about selling. It's recorded. You record the fact that you have a property and a subdivision, and you've got these different portions. You decide, do I want to have CRTs issued right now already in respect of all my portions that I subdivided in, and then I'll only hold my remaining extent over under the holding deed. Then if I've issued certificates of registered title for all the other portions, let's say I subdivided into 10 portions and I hold the remaining extent under the holding deed, then under those circumstances, each one of those portions now has a CRT that I now have to use to transfer it off in future. The remaining extent is the only thing that I hold under the holding deed, unless I want to transfer everything off in one transaction, or if I want to only transfer the remaining extent or only transfer certain ones, I would deal with each one of them under the title they are held. And that meaning the remaining extent, the remainder is held under the deed. I will use the deed as my holding deed, and then my certificates of registered title represents the different portions. Once I've had CRTs issued, they stand in the place of the deed of transfer.
Okay, thank you.
Okay. Right, there's a number of things that came in here, or a bunch of things that I received. Let me just see what is going on. Oh, it's not on the group. Okay, so it's not on the group. This is other people. Okay, right. So, seeing as my voice is starting to go, I just want to go and grab a glass of water. Can we take a 5-minute break and we will start again at 1:45? 1:45, or do you want 5 minutes, or do you want 10 minutes? Speak quickly. 5 minutes it is. Okay, so we'll start at oh, somebody said 10, but you're slow. Okay, everybody's saying 10. Right, okay, we'll start at 22:11. 22:11. We will start at 22:11. Oh, 12, sorry, 22:12, sorry. 22:12. You see how fast time goes. It goes so fast. We have so much to do. So my voice is really going. I'm just going to pop in here and say 11:40. That's when we're starting again. Okay. So we Oops, sorry, I'm late. I did not notice the time. Oh, I'm a minute late. And then my voice starts up again. Okay, I'm going to check those questions just now. There was something that I wanted to go back to quickly. Alan posted something, and I just want to quickly see because I forgot to go back to it. Where was it? It was. Oh, it's about the fractions. The fractions. Yeah. Oh, and regulation 30. It's about that six-figure decimal. Yeah. Regulation 30. Okay. Okay. So that's just the fractions and ownership, etc. Okay. So that, and then what is it now? Yes, Alan.
No, sorry,
Yes.
Mareki. I just wanted to. I was just sharing the question that was asked earlier from our manual to your manual.
Oh,
That's
okay.
where the figures were coming from. So I just shared that to you.
Oh, okay. I'll probably get to it now because we're going on in the pages. Then I'll be able to quickly deal with that. And then we just now stepped off momentarily off from the extending clauses. And I actually wanted to use a couple of questions to try and help to explain them. But let's just quickly see if I can lay my fingers on. I have so many different notes and questions that I want to let everybody practice on. And now I've got about 6 subfolders and lever arches, so arch files. So yeah, when I start looking for something during a lecture, I always get flustered by the time wasted to find an example or something, which irritates the heck out of me. Okay, so if I don't find it, I can't find it now, so I'm just going to leave it there, and then we're just going to continue on with the explanations. Oh, let me just quickly see questions that came in after we. Okay, it's Shimon said, don't we just continue? Repeat the question. First registration, first, okay. Further registered, under registered title. Shimon, I don't know what. Darani, first registered and still held by certificate of registered title number T1 with SG diagram and next. Yes?
You can just ignore that. When you were still asking us, how would you start it from B to C and C to D type of thing. So yeah, that was before you explained everything to us.
Okay.
Thank you.
But that looks correct to me, I think. Yeah. So we can just quickly have a look at them. I'm just quickly checking if there was a question. There's one here. The wording of the extending clause for Form TT in respect of a certificate of registered title. Okay, that extending clause is the Form TT. Is it for a specific matter that I have to share that? Or is it in relation to what we've dealt with?
No, it's just I just needed to consolidate because the extending clauses that I understand very well are those that are on page 86. So the one for title, I need to master them. So in terms of TT, for the one without a registered title, for the example in the book, it reads as follows: S will more fully appear from the annex diagram and held by deed of transfer number so. But I wanted to get an equivalent for the certificate of registered title, such that if you could help me in that regard as to the proper wording. Will it read as will more fully appear from the annex diagram?
Yes, it will. If it's a subdivision and we are dealing with not with a certificate of registered title, then it will just be as will more fully appear from diagram SG number, whatever the number is, and held by deed of transfer number, whatever the number is.
Yes.
And then if you didn't take out a certificate of registered title, and you just transferring off of the deed, it would be first, that's now following on, it will be first transferred by deed of transfer, whatever the number is, with diagram annexed. And then if it's a further transfer, it would follow first transferred by deed of transfer and held by whatever the second transfer was. So the sequence runs like this. You first start with as will appear, then you go on to the first version of Form UU, and that is then following when it was first created. You start with when it was created, that would be as will appear from. Now, when you now transfer for the first time, it will be, let's say it's a deed of transfer that was used, it will be first transferred and still held by the title deed that it was first transferred when you took transfer. So you still hold the property. It was first transferred to you, and you still hold it under that deed. So in other words, it's B's title deed, A to B. B's title deed is going to be the one, that number is going to be the number that you will refer to as first transferred, as a deed of transfer, transfer number, whatever the number is. So first transferred and still held by that specific deed with diagram or general plan annexed. So it depends on what you are using, and I'll use or what you are dealing with, whether it's a general plan or a general plan or a subdivisional diagram or a consolidation diagram. So first, if I create it, it is as will appear for Form TT. From UU follows on, first transferred and still held by the deed number with diagram annexed or with general plan annexed. Then, if it's then transferred, say now it's a deed of transfer 3 of 2020, then it will be first transferred by deed of transfer number 2 of whatever, with diagram annexed and held by deed of transfer number 3 of 2020.
Okay.
So that's how they jump and how they follow in sequence.
Yeah, Marika, that I understand. The example that I want is for the certificate of registered title in relation to just the first one, Form TT, right? So
yeah, that is as will appear from whatever diagram you have.
Yes.
So as will appear from the diagram number that you have.
Mm-hmm.
Okay, and that diagram is going to relate to a property that already exists and is held by a deed of transfer, for instance, or even it could be a certificate of registered title. So you use the diagram or the general plan that you refer to, and then you just refer to that number. So as will appear from whatever let's call it the diagram or plan you have, and then held by the deed that it's held under. Okay, so that's your first as will appear. Then from that, if you have a certificate of registered title, it will be first registered by deed of certificate of registered title with that number. So that's where you start off with. So first registered and still held by deed of transfer, whatever the certificate of registered title. Somebody's typing in my ears. So it's throwing me off dealing with hypothetical things in my head. So as I said, if I have a certificate of registered title, my first one will be as will more fully appear from diagram whatever held by deed of transfer, whatever it was held under. Then if a certificate was issued, it will be first the further transfer of the property would fall under UU, and that would be first registered and still held by certificate of registered title, whatever the numbers, let's call it 1 of 2002, with diagram annexed thereto. The diagram number follows that. Then if I transfer again, when I transfer again, it's going to be first registered by the certificate of registered title number T2 of 2002, for instance, with diagram, whatever it is, annexed thereto, and held by deed of transfer, what subsequently was issued as your title deed number.
So in summary, the TT, the holding part, in this case, you're not going to refer to the deed of transfer, but you then you're going to say, and held by certificate of registered title.
No, because the initial registration was issued under its form UU for the certificate. Okay, so the further one. Okay, let me first hear what it is, because the holding part, if you first start out with, is as will appear from your diagram, and then that diagram stems from a deed that you held, a property that's being subdivided, for instance, or consolidated. So that's where that comes from. Then the second one, if you now transfer after that, yes.
Yeah, the thing is, I'm not asking about the subsequent UUs and all of that. I'm only asking about the TT, right? Because that's what I need clarity on, and nothing else. So what I'm saying is with TT, because the way I would word the TT for a situation that involves a certificate of registered title, I would then say the following: as will more fully appear from the annex diagram and held by certificate of registered title. Is it how I would word it correctly?
You're not going to say and, firstly. You are going to say as will appear from, and then you note the diagram. Okay, so as will appear from, diagram SG number, and put in the diagram number / the year. Held by, not and, held by whatever it was held under. If that property was created and is still held under a certificate of registered title, then that is what you refer to. Then it will be as will appear from diagram SG number, put it in, held by certificate of registered title. If it was created and is held under a certificate of title, when it was created and a certificate of registered title was issued for a specific portion of land, then you will say, and you will essentially hold it, and this is specifically under in situations of consolidated title. So then you will hold it under that certificate, but you're not going to say certificate of consolidated title. No, you're just going to say certificate of registered title with the number CCT CRT. So that number of that title deed that was endorsed on it.
No, thank you. It's clear. Thanks.
Okay, but I explained that at the beginning. I said you're either going to hold it under an existing deed, or you can actually, after things have been consolidated, etc., you could have it under a CRT, and then that's where the first registered part comes in from, in the form UU and forward. Yeah, because if it's a certificate, then we refer to registered, and if it's not, then you refer to a deed of transfer. So that's basically it. Is there anyone else that doesn't understand this? Anyone? Sleelan, I'm going to talk to you now. The thing is, you're not transferring the certificate. You're transferring the certificate, the property that's held by a certificate, because I see Faith Huntley is saying, yeah, it sounds like Enoch is transferring the certificate from A to B, but it's really not the certificate that's being transferred. It is the property held under a certificate of registered title that's being transferred. Sleelan?
I just wanted to ask,
yes,
if I can just explain it quickly. In the note, it says that X sells portion 1 to Y, and then where Y would then sell the portion to X. do we then only add the and still held? So
Yeah.
do we then if you're saying that you would then transfer it from from the first property transfer, and then there's another property transfer and another one, you would keep on adding and still held?
Yeah, it's only that is right. I'm actually looking at what I found your example, and it starts off by illustrative example, and it says assume that X is the owner of Earth 4 Norwood, and he holds this piece of land by deed of transfer number 123 of 1982. And then in 94, X decides to subdivide. So he asks the surveyor to survey and then have it approved by the Surveyor General. So the so-called parent diagram that we refer to, because that's a parent, that's where it stems from, as well as the subdivisional diagram, and assume that the Surveyor General has given the subdivisional diagram number 321 of 94 to subdivide Earth 4 into portion 1 of Earth 4 and the remaining extent. And then in 94, X sells portion 1 to Y and asks you to attend to the transfer. So all along, X is the owner and holds in his title deed portion 1 and the remaining extent of Earth 4. And then he now says, okay, now I'm going to sell it, and please transfer it off to Y, but only portion 1, transfer portion 1 off. Then we will literally follow the extending clause as it's there. It says, as will more fully appear from a next diagram, because we use the diagram as the point of departure. It's all good and well to see it here in words, but in the exam, you may very well get a diagram that's attached to your exam paper, and you have to be able to interpret the diagram in order to complete this. So as will appear, firstly, I have a diagram, so it's as will more fully appear from TT's wording from the annex diagram SG number and held by which deed? The deed that X held Earth 4 under, the whole of Earth 4. So as will more fully appear from the next diagram, SG number A321 of 1994 and held by deed of transfer number T123 of 1982. That's our general point of departure. So that's our, let's call it our general rule, our rule of thumb, it says there. So that's our point of departure. Now, it says here, now we don't, they don't say to you, okay, the registrar has endorsed or rather has registered that transfer, and the number for that transfer is T whatever. So now they say to you, assume that Y's X who transferred to Y's deed number is T456 of 1994. Okay, then under those circumstances, we go on and we say in 96, Y sells portion 1 to Z. This subsequent transfer of portion 1 is now a transfer of a piece of land, which is already held under that title deed. Okay, so because there wasn't a CRT taken out here, we will say first transferred and still held by deed of transfer number T456 of 1994 with diagram number the same as the original diagram number A321 of 1994. So this is a situation where a CRT was not issued, okay, because I don't have to if I'm dealing with portion 1, but if I had transferred the remaining extent first, then I would have had to take out a certificate of registered title first in respect of portion 1, and then I would, when I transfer portion 1, then I would deal with the CRT in my held by portions of my forms. Okay, so first transferred and still held. So the first time that I hold that the property was transferred, it stemmed from that diagram. Then after that, now, since it's been registered, it will always say first transferred and still held by. And if it's a certificate of registered title, it would be first registered and still held by certificate of registered title number, whatever it is, with diagram annexed. Okay.
I just want to know if if Z would then decide to sell it to A, would we still then use and still held, or do we not add
No.
that anymore?
No, you now then you say first transferred by deed of transfer number T456 of 1994 with diagram annexed number A321 of 1994 held by deed of transfer T let's call it 789 of 1996. Does that make sense?
Yes, it does now. Thank you.
Okay, so just to repeat that, if Z is now transferring on, then it's going to be first transferred by deed of transfer, and then let's call that title deed T789 of 1996 with diagram SG number A321 of 1994 annexed, held by Z's deed of transfer T whatever it is called. Okay, so easy enough. So only when I do that, when we start off with as will appear and we then go into our next transfer, it will be that portion that, or the wording first transferred or registered and still held by that same title deed. Okay. Pizza Sai says, so can you transfer a portion without having created a CRT? Yes, yes, you can. Okay, when we do CRTs, we will explain that in more depth. It's good to now understand that I'll always hold my remaining extent under the holding deed, and I will issue a certificate of registered title for other portions, but I don't have to. I don't always have to. It's not obligatory. Okay. The thing is you have to start thinking about the different aspects of the deed. And as we go on to the more specialized areas such as CRTs, consolidation, subdivisions, partitions, bonds, all of these things, then we literally start thinking about what we learned as general rules and how do we apply them in future. So can we assume that there's relative clarity for up to our knowledge at this point regarding CRTs? Good enough, right? I will in any way upload a graphic explanation that shows how we deal with them, and a voice note. Okay. So now we can continue.
Sorry,
yes,
Marika.
is there somebody that has a question? Yes.
Yes. With a general plan, do we relate or annex?
Always relate to a general plan. Remember, I said you can't annex it; it's too big. We only annex that A4 diagram. We only relate to that big general plan.
Thank you.
Okay, here's another one that I want to let you think about, and that is, let's say that there's a township, and there's a general plan that relates to, let's say, 200 different urban. And I'm the developer, and the development was opened, and a lot of urban has been transferred to other people. And now at this point, there's a person who wants to buy Earth 100, for instance, and you have to deal with the transfer. Now, the first thing you have to remember is that that general plan is filed in the deeds registry, okay? And that relates to that township. So when I now have to deal with, say for instance, portion 100 or even Earth 100 for that matter, then I'm going to refer to that general plan. As in our property descriptions, we're just going to say relating to that general plan. But remember, it was initially created by a general plan. So our as will appear will be as will appear from general plan. Okay, with the holding deed, let's say whatever the deed for that township was that it was held under, you give that a holding deed, you use that there, and then subsequently it will be first transferred and still held by, and we continue with the deed, that the number that was given when IRF 100 was now transferred to that person. Okay, with diagram relating thereto. It's important to remember that with townships and the general plans, those are always to be permanently filed, and you will always just continue with your further transfers of the urban in relation to that general plan. Okay. When those townships are open, they come with conditions of establishment, and those conditions of establishment is also scanned in the deeds office as part of the record. So your conditions will come directly from the conditions of establishment that the local authority imposed. Okay. So and we do township establishment, right? Okay, so let's see where we are at this point in time. We've dealt with okay, we can actually continue on where we first had that first transferred and still held by deed of transfer situation. Now, if that continues on, then it's going to be first transferred by deed of transfer 456 of 94 with diagram SG whatever annexed thereto and held by deed of transfer 789 of 1996. So you can just follow them as they continue on. So it's from the part below the illustrative example. You're going to get your first transfer at the bottom over to the top of the first page. Then about 2/3 down or 1/3 down, you're going to get the consecutive transfer that has the as and still held. And then 2/3 down, you'll get first transferred by deed of transfer with diagram annexed thereto and held by the other deed. So that basically follows your sequence of what we generally use and how we continue on with. Now, remember there are exceptions, and those exceptions are purely those situations where, for instance, there was never a previous reference to a diagram or a general plan. Then you can simply just say held by deed of transfer. And if it was first transferred by, in the deeds in your holding deed, it says first transferred by with a deed number and held by deed of transfer without a reference of a deed, a diagram or a general plan. Then you just don't use the general plan or the diagram. There, I have to say, every deeds office is different on that. I know that you don't have to insert it, but for instance, KZN rejects you if there is a general or a diagram and you can't refer to the diagram and you don't refer to it. You have to do an owner research first on the property and find that diagram in order to correctly refer to it in your extending clause. So that's KZN practice. It's not necessarily what happens in the other deeds offices. I'll check with the others. Okay, so if we have those extending clauses down, which I do believe we basically have, then we can just quickly look at property descriptions. Then we have done well up to this point, and then we need to go on to plotting of conditions. So the different properties here, the first one that's looked at is one that we constantly have heard, and that's the urban. And you'll also see portion 1 of 13 of IRF 523 is also an example of a portion of a portion here. And then in a situation where, for instance, portion 3 has been subdivided, then you have, that's under 4.2, you have the remainder of portion 3 of 6. So the remainder of the portion 3 that was subdivided from portion 6 of the IRF 621. So can you see a portion of a portion of a portion? You literally can have a portion of a portion of a portion that is defined as a parcel or a portion of land. Agricultural property, you already know that we have a number for that, and there's a couple of examples there for purposes of property descriptions for agricultural land. And then on that's in 4.3 and 4.4, subdivision and consolidation of land. Okay, so very important here is that the different provinces do deal with the consolidations differently, and this part, this is like an introduction. It's like wet your feet just on subdivisions and consolidations. And it's quite important, because if you just grasp the next couple of pages, it's going to make it easier to deal with the conditions. As I said before, conditions could be a bit intimidating, as is Form TT and UU, but it's really not the most difficult things. So on 4.4, subdivision consolidation of land, it starts off there to refer to Pietermaritzburg registry. That it says it's unique in its form, because we have the PDA, KZN PDA, that is that Planning and Development Act, 6 of 2000 Act, and 8. And then we have the Natal Roads Act, and we have the Town Planning Ordinance 27 of 49. When did I refer to 27 of 49? Those of you who stayed late on Wednesday. Okay, I referred to the Ordinance 27 of 1949, when we also referred to the Ordinance 10 of 37 in the conditions that I quickly went through in that question on prepare a power of attorney and a draft deed. Which do I take over and which do I leave out or away out from my deed? Other ordinances are for KZN is obviously important for us here, as opposed to other provinces. And then you can just look at that. If you are in this province, then you can further consider the content of that, or you can contact me. The consolidation of properties and the qualification of the conditions, very important here. You'll see, for instance, if we have a consolidation diagram, and just for the sake of this, I'm just going to make this a bit smaller. Oops, no, smaller. So this is a consolidation diagram. You can see there's the remainder that's lying here. This triangle we just subdivided, and that was portion 6, remember? So now we're consolidating this with the earth that is right next to it, and that will become now earth 1518, earth 1518 Woodview. Okay, so important to always note on your diagrams, servitude notes. There's an S&D, see it continues on, a sewer and drain servitude, and then there's also a sewer and drain servitude on both of the properties as they lie here, because they're connected, interconnected, and continuing on. Okay, so and then it just basically tells you the one is portion 6, which we just created, that one there, that one there. We just created that, and that is being consolidated with earth 1007. Okay, 1007. Oh, I'm drawing this with my mouse, so it looks very bad. 1007. Okay, so that is being consolidated with the newly created portion 6 of 970. So this is a typical consolidation diagram, and when we deal with those conditions of the 2 urban, there's different manners in which it's dealt with. Some provinces, it says in your notes, just refer to the former portion 6 and then cites their conditions, and then the former portion 1007, which is, and also you list their conditions. And then in Pietermaritzburg, when we do consolidation subdivisions, you're going to see that we literally qualify the conditions for every component. So we would say as to the component lettered A and A, small a D on the diagram, SG whatever, and we will say that's the conditions, and as to the lettered component A, small a D, C, D capitals on that diagram and list their conditions. Obviously, there's conditions that lapse, and when they lapse, we don't bring a section 68(1) application. Okay, that's one of your sundry applications. And I have previously referred to regulation 68. You have to tell section 68 apart from regulation 68, because regulation 68 relates to a lost title deed, while section 68 relates to the lapsing of servitudes. Okay, so and then you bring an application to the deeds registry with your transfer documents that a specific condition has lapsed. Okay, and then that title deed is endorsed with a rubber stamp that says this condition has lapsed. There are certain conditions which we dealt with or quickly touched on Wednesday for those who stayed late for KZN under the Chief Registrar's Circular, or rather the Registrar, KZN Registrar Circular 2 of 2009 that says certain conditions you just don't carry forward. They just lapse automatically. Okay, so now we can look at 5, which again just deals with property descriptions. I have mentioned these quite a number of times, so I'm not going to go through them again. In 5.2 specifically, pivot deed. Okay, as I said before, this is the Cape Town, and it's unique to Cape Town registries, where they refer to the pivot deed, and those conditions are verbatim quoted and carried forward to in the deeds that follow on. If it's created in a pivot deed, then you would say subject further to certain conditions and carry them forward. And if they lapse, then it's also practice to say not subject to. Not subject to. That's when you note the fact that certain pivot conditions are not carried forward. There's been changes in this practice as well, and as I said, I am not really on top of conditions and how you deal with them in the Cape, but I have arranged for the guys that are from the Cape Town for one of my colleagues to take you through additional information on that. I also note, I just want to quickly ask, is there anybody from Bloemfontein or the Free State? Is anybody on from the Free State part of the course? Okay, because there are here and there Bloemfontein property descriptions that seem to look somewhat, not completely, but somewhat like the Cape Town conditions as well. Those two provinces I've only dealt with in sectional title matters and not in freehold properties or farms. Okay, so now we're going to go on to chapter 8. Is everybody with me still? Okay, I'm going to assume you are with me still. Now we're going to go on to the conditions. Okay. Yes, okay, I've got people that saying they are indeed with me, so we are continuing. So, chapter 8, general conditions. There is a hierarchy. Thank you for everybody saying you're still with us. So I see there's something. You just check for questions. No questions. Great. Beth Zaside, I did answer you on you can transfer a portion without a created CRT. Yeah. Okay, I've done that. Faith, can we deal with registration later? What do you mean, Faith? Oh, you wanted us to deal with the fractions. Okay. Just tell me again which paragraph is that? Oh, wait. Somebody said it was it 82? Page 82, your 82 or something. Let me quickly. Oh, there it is. I found it. It's 86. Okay. And regulation. Oh, Faith. Yeah. Thanks for reminding me because I've clearly forgotten about that. Okay. So you have to differentiate here between two situations. So the one is I hold a property and I am one of 3 or 4 different people who are the registered owners. I just want to quickly open up a Word document. See, new. You can see this, right? It's a blank page, right? So let's explain it like this. I just want to make it a bit bigger. Yes. Okay, so we have Earth, let's say 1012, let's say Garsfontein Township, registration, division, JR. In extent or measuring, say 1,500 square meters. I have that in words. Square meters, right? So now this property vested in the following people. 1, let's say Joe Soap. 2, Jane Plain. Doe. And Jack. Okay, so all of these people, they hold this property in undivided shares. Now we have to look at the situation where it's vested in unequal shares and when we give transfer to unequal shares. So when we are transferring property, it means it has already vested in a specific share or fraction in the different owners. So if I'm transferring, when I transfer the property, I would refer to the specific share in relation to that property. If I have purchased it and it's now being vested to me in certain shares, then I would literally deal with it by immediately referring to the in the vesting clause in relation to my share. So if we have A receiving in respect of the property, say 1/2 share, okay, and we have Jane Plain here having 1/4, and we have, for instance, Joe Doe here with 1/8, and we have 1/8 here for Joe Black. So each one of them are holding in this specific ratio. Then clearly I don't have equal shares. If I only cited the parties without reference to their different shares, it means that the parties have been vested in equal shares. So if it's equal shares, each one of them would have received a 1/4 share, and therefore they would not have to, you would not have to actually say it is an 1/8 or each having a quarter of the shares. Okay, so remember that in future, is if we don't say anything, it will be equal shares. But in those situations where it's actually uneven or unequal shares, then we have to state exactly how much it is. So under these circumstances, when I vest my different parties, I would refer to the share that it is being vested to each of the parties. And when I am transferring, for instance, only only Jane and Joe Doe's, Jane Plain and Joe Doe's shares, then I would literally only be transferring those two, the 1/4 and the 1/8. Okay, but now if I'm transferring only these two portions of the undivided share, then after I've cited them, I have to say what the aggregate share is. So now a share is expressed in no more than 2 denominators, or in a 6-digit decimal figure. So 1/8 can be further, let's say, broken up into, or rather further expressed as, say, 2/16. We can do that. Or we can say literally Jane Plain's 1/4 is equal to 2/8. 2/8. So in other words, if I am transferring only these two people's shares, then I would literally refer to them as such. And then when I transfer, I would say together comprising A. And then what would it be? This would be 2/8 and 1/8. Then together transferring 3/8. 3/8. Okay. That would be your aggregate share. So it would be together comprising a 4/8. Is it 4/8? Yeah, no, 3/8. Sorry. So the aggregate here for let's just mark them in yellow or something. And right there, and that. The two of them together is, just make this another color, is 3/8. That's the aggregate share. So if we're only transferring these two people's shares, then we will say, after we've cited the two parties, okay, in our where we are transferring off, we would literally say together comprising of a 3/8 share in the following property or properties. Okay, and then I would list my property or properties. If this was as per your, that's now the general two denominators. If this is the case, then if it's a case that we are over the two common denominators, we can work it back. You can work it back. So in your question, you have, let's see, you have 1/8 in your question now. You have 1/8, 1/56, and you have what else? 7/112, so 712, and you have 1/112. Okay, so I can attempt, let's say this, we can attempt to use what we have and convert it into another fraction if it's possible, so that we can express them as the highest possible denominator. If that's impossible, so in other words, 7/112 is not going to be it's not going to be capable of being converted anywhere. Okay, so you can't change this to another fraction that has two denominators here. Okay, So if I can't do that, then I have to refer to these as described as a decimal figure. So in this case, if I have 712, then my expression is this. So I would literally refer to it being the 0,0625 share to the property. And then the 112, just look at that, that will be 0, comma, oops, 0.94 share. So that is then my share. Okay. Only these can be expressed in a fraction because of the regulation that says if it goes over 2 digits, I have to express it in a 4 decimal share as such. So I would literally, and remember this is you must take your calculator in. You're not allowed your cell phone, so you're not going to be able to use your cell phones as calculators. You've got to take a separate calculator in. So for these aspects, to express the shares, I would literally express them as specific fractions of, not fractions, as decimal shares, decimal shares. Okay. Now remember, each one of these parties that are settled or vested with a specific fraction, they all will be numbered entities. Remember, so in other words, if Joe Soap is unmarried, he will be cited as an unmarried person, and Jane Plain will be, say for instance, married out of community of property, that I would cite her as such. Depending on obviously whether or not that asset is excluded from the joint estate or not. Joe Doe with his 8, let's say he's married in accordance with the laws of a different country, and then Jack Black is, let's say he is a civil union without an antenuptial contract. So it's not a partnership, it's a contract, it's a marriage. So you would have to deal with each one of their citations, and then each one of them would receive the property in a specific share. So over and above the fact that you'd have to cite them properly, you would also have to cite their portions into the property. And then when they all transfer their shares, and if I look at this situation, for instance, clearly this does not calculate to a whole property, so it doesn't make up 100%. Okay, so clearly from this, it doesn't make up, if I quickly look at these fractions, it doesn't make up 100%. This title deed only holds these undivided shares, and it doesn't make up the whole of the property. So if I then want to transfer all of these undivided shares jointly, I would do that in one title deed, and I would then only transfer their aggregate share. So if I quickly look at that from a mathematical point of view, then 156 is going to be 212s. 212s. Just from mathematics, those of you following will say understand. So if so, what would be a 1/8? A 1/8 expressed in shares of 102. Anyone that's following? Yes, 14. Yeah, so it would be 14 112. So if I had to all convert them into these kind of shares, okay, but bear in mind that I can't have a share of 112 that because it's 3 figures as the denominator. So we would literally have to convert them into shares, and that would mean if we're now transferring all of these shares together, we are going to be transferring in aggregate 14 plus, well, first 14 112s. So that would be a 0.1250, and that would be your share expressed as a 112. Sorry, that would be that one. The 2-1, yeah, it's just going to be. I hope I'm correct because double check me. So that one would be that. And then if I count all of them together, then it's going to be, if I transfer them all off, it's going to be my different fractions, basically, oh, there's a 3 zeros. That's all added together, okay? They've all been added together, and then it would be, I'm transferring the combined percentage of the share to whoever it is that's acquiring it. So it would be that share in into Earth 102 or 106 or whatever, wherever it is situated. But I would then look at all my fractions, add them all together, and see if I can now you know, convert them back into a fraction if it's possible, if that is expressible in 2 digits of the denominators. If not, I would count all the, or add all of the percentages and then transfer it as an aggregate share in the specific property. Is that clear?
So Marike,
Yes.
with this example you're giving, shouldn't the different fractions add up to 1?
If it is, it's a 100% equals 1. So if I have different fractions that can add up and is expressible by 2 common denominators, then if I can add them up, then it will make 1. If it's percentages, it has to be, if I want to say it is 100%, the full ownership and the full property or all the properties together, then it has to make up 100% of the shares.
Okay, so I guess
so that is an expression of a percentage of the shares expressed as a 6-digit decimal.
Okay, thanks.
Because of your example, it that is given as 7/12. I don't think I've ever seen people owning things in 112, because that would mean that you've got 112 transferees or transferors in a deed. So it's more likely that you would end up with 8ths or 12ths than actually this. But then there is a concept in law called fractional ownership. Fractional ownership, you get it especially with lodges, game farms, etc., and then they would their investors would actually own in a fraction. Then we can get up to higher equation, higher kind of fractions that is then converted. Okay, so I think this is basically your theory. Your theory that would come up in theory in your your first paper. You will see that. Okay, but fractional ownership is a very alive and well thing. Alan says 112 works out to a lump of sand. Yeah, it does. It does feel like it. Hey, it's a lot. It's a lot of nothing. So I think what's his name, Mike, tried to get you to think of by using that example, because you won't get that kind of example given by Alan West or anybody like that. It's just to make you see and think about the potential expression of the 6-figure decimal, okay, which is the regulation. And also, once again, to reaffirm the fact that if we explain one thing, it means that you have to go and look at the regulations behind that section or behind that concept that we've explained. I really want to start on conditions and plotting them. Faith Huntley, your hand is up. Do you still have a question? Not. Your hand is up, Faith Huntley, but you're not speaking to me. So I'm going to say that's kind of like an absurd situation. But at the end of the day, you can make up a couple of examples and play with it as you prepare your documents, etc. What's important is to know how to vest and how to divest and how to reference them. And I've got an example that I'll upload to you because I had to deal with an estate with about 7 or 8 people. No, not an estate, an old transfer in that regard. So now today we've touched on different aspects of section 22, 24. You can read 23 as well. That's important. And we also spoke about 17 again on citations, right? So now I have to start just with plotting of conditions, and then just while hopefully the majority of people are still here, I'm going to say this right now. We have an extra lecture on I'm typing it on, Marijke can't spell or speak, it seems today. On Tuesday. And on Tuesday, we start at 5:30 and we go to 20:30. And depending on how we do on that day, I personally think we have to have an extra further lecture as well. So we need to decide whether that's going to be the Friday or I think the Thursday is the notarial practice, or whatever the situation is. So it's either the Thursday or the Friday, one of the two. Okay, so important there. I'm going to ask. You're saying okay? Yeah, we can do 7 to 10. We can do 7 to 10. Those of you who want to do 7 to 10, quickly sort it out amongst yourself and then post what you decided on the group. Okay, so. We'll have an extra lecture because we need to progress faster, and we still want to go through a lot of examples. Okay, notarial practice is starting on the 19th. Okay, so it's not now. Okay, so we can still do some extra lectures without being affected by notarial practice. So let's go through Tuesday, and then I'm certain I'm going to ask you to let's do an extra further lecture. So now, yes.
Sorry, Marijke, it's Alan. Do you mind if I ask a quick question?
Oh, no problem.
Just in respect to the ratios that you've just shown in terms of the shares of the land. Yes. When we cite these, the regulation 30 is saying that we must use the lowest number on the ratio. Okay, yes. So in other words, 1/8, 156. If it goes beyond that, then you cite it in its decimal form. So yes. The question that I want to know is that we don't have to convert everything to decimal form.
No.
Okay, so we can have it mixed.
Yes.
Okay.
Yes.
That's fine. Thank you.
Okay, no problem. I think there's a CRC on that one. I'll just have a look for the right one and upload that as well. So now we have to really start on conditions and the plotting of conditions. And I'm going to immediately just touch on the fact that there are conditions that contain, for instance, conditions of relating to, for instance, a servitude, let's say a water pipeline. And then we have conditions that also include ancillary rights. Okay, so the one is a condition that stems from the fact that it is situated at a specific place or space. Okay, and when we have ancillary rights, that means that in order to get to a specific servitude area, to service it, for instance, you have to traverse another property, or you have to, in the course of servicing that servitude area, you have to excavate land, ground, soil, for that matter. You have to excavate it, and you have to deposit it temporarily on that property. So the one would be purely and plainly just the right to carry, let's say, pipelines across a specific property within the servitude area. And then the one that actually refers to ancillary rights would simply state this is the servitude together with ancillary rights. And once I've got that ancillary rights, I've got to deal with it in a specific manner. And I have to know, when do I refer only to the servitude, when is a property or a portion or a newly created area subject to the whole of the servitude, and when is it just subject to, for instance, the ancillary rights. So if you look at plotting and plotting of conditions and the qualification of conditions, then the example that they are giving is in respect of a property, a farm called prescription. I think in your manual it is page 100. Page 100. Right, it starts on page 97, where it starts with plotting of conditions, and then sorry, it's actually page your page 97, plotting and qualification of conditions, not page 100. Sorry, page 97 in your manual. So plotting and qualification of conditions, and this is really one of the best examples because this is taken verbatim out of Alan West's book, Practitioner's Guide to Conveyancing and Notarial Practice. So as it is verbatim, it is taken from Alan's book. So it's a really good example. So it starts off in your book, or rather in your notes, with reference to this farm prescription. And it immediately tells you there's a title deed for this farm. And that title deed number is T3230 of 2006. 2330 of 2006. So that's my T number. So I have this farm, and the farm number is prescription 312, held by that deed. And in that deed, we have a number of conditions, right? So let's quickly look at your chapter here, and I can open that up for you. Just quickly get to plotting up. There we are. So these are your conditions. That farm is subject to these conditions. Okay. So our first one